personal explanations, introduction of bills. The Miscellaneous Provisions FATF Compliance Bill 2026 in the name of the Minister of Finance.
I'm advised, even though the bill is in the name of the Minister of Finance, the Honorable Attorney General has overall supervisory jurisdiction over this. Honorable Attorney General.
Mr. Speaker, in accordance with Standing Order 64-1B, I beg to move that the next stage of the Miscellaneous Provisions FATF Compliance Bill 2026 be taken later in the proceedings.
Honourable members, the question is that the next stage of the Miscellaneous Provisions FATF Compliance Bill 2026 be taken later in the proceedings. All in favour say aye. Aye. Any against? The ayes have it.
Motions relating to the business or sittings of the House and moved by a minister.
Which one is this? Of government business.
Thank you kindly, Mr. Speaker. Mr. Speaker, in accordance with Standing Order 33-5, I seek the leave of the House to consider government business instead of private members' business.
Honourable members, the question is that the House consider government business instead of private members' business. Those in favour say aye. Aye. Any against? The ayes have it.
Public business, government business, bills, second reading.
Honourable Attorney General.
Mr. Speaker, I beg to move that a bill entitled An Act to Amend the Trustees' Ordinance, Chapter 4 of 1939, the Proceeds of Crime Act, Chapter 1127, the Police Service Act, Chapter 1501, the Registration of Clubs Act, Chapter 2101, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Companies Act, Chapter 8101, the Partnership Act, Chapter 8102, the Registration of Business Names Act, Chapter 8285, the Licensing of Dealers, Precious Metals and Stones Act, Chapter 8406, the Non-Profit Organizations Act, Number 7 of 2019, and the Counter-Proliferation Financing Act, Number 8 of 2025, be now read a second time. Mr. Speaker, this bill comes before this House at a time when Trinidad and Tobago, having started the 5th round mutual evaluation process in August of 2025, being the first country of CFATF to do so, will be the subject of an on-site review by the CFATF team some 2 weeks from today. As members will be aware by now, the Financial Action Task Force is the global anti-money laundering and anti-terrorist financing watchdog, which sets international standards that aim to target terrorist financing and money laundering activities. It is an international body made up of 40 countries and a number of FATF-style regional bodies, including the CFATF, of which Trinidad and Tobago is a member. CFATF is responsible for promoting the effective implementation of the FATF recommendations by their membership and in providing expertise and input in FATF policy making. FATF uses a peer review system to ensure that countries comply with the FATF recommendations. Therefore, in March, other countries within CFATF will be examining Trinidad and Tobago's legislation, administrative structures, and the effectiveness of the laws enacted to determine whether Trinidad and Tobago is in fact compliant with the recommendations. Criterion 24 of the FATF requires, broadly speaking, greater transparency. In some cases, that is linked to identifying the ultimate beneficial owner of assets, the UBU. In other cases, trusts and beneficiaries are supposed to be clearly identified. There are changes which this bill before the House proposes to the Companies Act, the Partnership Act, the Registration of Business Names Act, and the Trustees Ordinance to bring those statutes into compliance with the FATF recommendations. The Financial Intelligence Unit Act, the Proceeds of Crime Act, the Licensing of Dealers, and Counter-Proliferation Financing Act follow a somewhat different theme. The bill seeks to close the technical compliance obligations of Trinidad and Tobago that, subsequent to the miscellaneous provisions FATF Compliance Bill of 2025, were identified as requiring further legislative attention in order to ensure that all of our obligations are met. Mr. Speaker, the bill would amend 11 pieces of legislation: the Trustees Ordinance, the Proceeds of Crime Act, the Police Service Act, the Registration of Clubs Act, the Financial Intelligence Unit of Trinidad and Tobago Act, the Companies Act, the Partnership Act, the Registration of Business Names Act, the Licensing of Dealers, Precious Metals and Stones Act, the Non-Profit Organization Act, and the Counter-Proliferation Financing Act of 2025. I'll take the pieces of legislation one by one. The amendments to the Trustees Ordinance, with which I begin, would seek to ensure that recommendation 25.4 and 25.5 of the FATF are met. 25.4 requires countries to ensure that trustees of an express trust and persons holding equivalent positions in similar legal arrangements must hold and keep basic information on other regulated agents of service providers to the trust and similar legal arrangements, including but not limited to investment advisors, managers, accountants, and tax advisors. Criterion 25.5 states that all the information required under 25.4 should be maintained for at least 5 years after the trustee or person holding that position in a similar legal arrangement ceases to be involved in the trust or arrangement. So we have included in the amendments in clause 2, sub D, Roman 1, to section 10D, we've inserted a new 3DB. Criterion 25.6 requires that any information held by the trustee on a person holding the equivalent position in a similar legal arrangement, including the information required in 25.4, be kept accurate and up to date, and that the information be updated within a reasonable period following any change. That amendment is reflected in the bill in 2 sub D, Roman 1. Criterion 25.7 is reflected in 2F of the bill. In the Proceeds of Crime Act, we've amended the anti-money laundering supervision of electronic money issuers to take that out of the FIUTT and to put it in the central bank. That's in section 2. Now, there is another amendment, and this one amends the expression financial institution. Financial institution is a broad term. It refers to not only to credit unions which are registered under the Cooperative Societies Act. Cooperative societies itself is a large term. It captures various types of societies established for the promotion of the economic welfare of its members in accordance with cooperative principles, or a society established to facilitate the operations of such a society under the Cooperative Societies Act. These include cooperatives established for the pooling of agricultural resources and automotive resources. Such societies are not intended to be captured by the FATF standards for AML, CFT, CPF supervision. So the amendment ensures that only credit unions, properly so-called, are subject to the AML, CFT, CPF laws, and that the very strict standards are not applied unintentionally to other types of cooperative activities. The Police Service Act is amended to correct a cross-reference error. The Registration of Clubs Act is to be amended to ensure that Criterion 28.1 of the FATF recommendations is given effect. Under Criterion 28, casinos are required to be subject to legal or regulatory measures which prevent criminals and their associates from holding or being the beneficial owner of a significant or controlling interest, or holding a management function in or being the operator of a casino. The Financial Intelligence Unit Act is being amended to deal with certain administrative matters which are time-related. The Companies Act is being amended to treat with the ultimate beneficial owner theme. The FATF recommendations in Criterion 24.6 provide that companies must obtain and hold adequate, accurate, and up-to-date beneficial ownership information. To further ensure that adequate information for the identification of the beneficial owner of the company is maintained, Section 9 is amended to also include the individual's occupation in the list of beneficial owner details which are to be provided in the Articles of Incorporation. Criterion 24.5 requires that basic information be obtained and recorded, including the register of members and the number of shares held by each member. Section 33(1) large B is being deleted. A new subsection is being substituted to prescribe that the company must submit to the registrar a return of the issuance or transfer of the shares or membership interests. The Partnership Act, again in keeping with the ultimate beneficial owner strictures, is being amended to ensure that Trinidad and Tobago complies adequately with criterion 24A of the FATF recommendations, which requires that there should exist mechanisms to ensure that beneficial ownership information provided to the registry is adequate, accurate, and up to date by outlining an additional category of persons which may submit the return of beneficial ownership for a firm. It is felt that the Partnership Act should include provisions which permit the appointment of an authorized corporate service provider who should sign and submit beneficial ownership disclosure documents to the registrar on behalf of a partner of a firm. As such, the amendment speaks to this. The Registration of Business Act, consistent again with the UBO strictures, ultimate beneficial owner strictures, seeks to further criterion 2414 of the FATF, which necessitates amendments to ensure that responsibilities to comply with FATF methodology are proportionate and carry dissuasive sanctions. The shortening of time and other administrative changes are meant to do exactly that. Insofar as the Licensing of Dealers, Precious Metals and Stones Act is concerned, that is being amended to give effect to Recommendation 28. Recommendation 28 relates to dealers in precious metals and stones. Under the Licensing of Dealers in Precious Metals and Stones Act, Chapter 8406, dealers in precious metals and stones obtain licenses to carry on activities under the Act. Persons holding such a license, they are considered to be listed businesses pursuant to the first schedule of the POCA, the Proceeds of Crime Act, under the heading of jewelry. As such, persons engaged in the business of jewelry are also required to register with the FIU-TT pursuant to Section 18 large B of the FIU Act. Similar to the requirement for casinos, FATF Recommendation 28 requires legislative measures in place to effectively prevent criminals and their associates from holding or being the beneficial owner of a significant or controlling interest, or holding a management function in, or being the operator of a dealer in precious metals and stones. While the Act does provide for the licensing of dealers in precious metals and stones, it does not expressly provide for the denial or revocation of a registration or license to effectively prevent criminals and their associates from holding or being the beneficial owner of a significant or controlling interest, or holding a management function in or being the operator of a dealer in precious metals and stones. As such, the bill in Clause 10 would make provision for this. Criterion 28 3 of the FATF recommendations also mandates that dealers in precious metals and stones be monitored and supervised for compliance with AML, CFT, CPF measures. While the FIU Act contains provisions requiring the registration of listed businesses with the FIU for AML, CFT, CPF supervision, the Act does not contain similar provisions. Therefore, a gap exists whereby an applicant may obtain a license pursuant to the Act and continue to carry on activities thereafter without being registered with the FIU. The bill would therefore in Clause 10 make provision for such registration. The Non-Profit Act is being brought into line with Recommendation 24.5. Again, the ultimate beneficial ownership theme is present here. It requires that basic information be maintained and recorded. References to trust are supposed to be tightly regulated. The Counter-Proliferation Financing Act 2025, which was Act 8, number 8 of 2025, is also to be amended. That act came into effect upon assent on the 22nd of October 2025. The proposed amendment to Section 4 seeks to implement FATF Recommendation 1 by ensuring that national and institutional proliferation risk assessments are conducted, risk-based policies are adopted, and proportionate supervisory measures are applied. Criterion 1.11 requires countries to implement risk-based measures proportionate to the risk identified based on the understanding of their proliferation financing risk and to allocate resources efficiently to mitigate proliferation financing risk. Section 4, sub 3 of the Act shares a similar intent as Section 55.2 of the POCA, Proceeds of Crime Act, Section 22, Lard C, sub 2 of the ATA, the Anti-Terrorism Act, as well. But a key difference exists between 55.2 of POCA and Section 22.2 of the ATA. Under the Proceeds of Crime Act, the financial institution or listed business is required to pay special attention to the transactions listed in subsections A, Roman 1 and 2, and to examine the background and purpose of all transactions which have no economic or visible legal purpose under paragraph E, and to make to the supervisory authority written findings after their examinations were necessary. Under the ATA, the financial institution or listed business is required to pay special attention to and report all transactions listed under subsections A, Roman 1 and 2 to the FIU. To prevent the dissipation of funds as it relates to the offense of terrorist financing, a report to the FIU is required rather than the provision of findings where necessary to the supervisory authority as required under POCA. The construction of 22 Lard C2 of the ATA causes a literal interpretation that all such transactions, all, whether suspicious or not, must be reported to the FIU. This is the same interpretation that would apply to 4.3a of the Counter Proliferation Financing Act of 2025. The reporting of all such transactions to the FIU can cause an overload of junk reporting to the FIU and would place an unreasonable burden on the financial institutions and listed businesses. So after examination of the various amendments made to 55(2) of POCA from 2000 to 2014, the intention to only report suspicious transactions or suspicious activity to the FIU became something that was necessary. Accordingly, Clause 12 of the bill, at paragraph A, seeks to amend the Counter-Proliferation Financing Act of 2025 in Section 4 by amending subsection 3 and inserting a new subsection 3 large e. The intention for financial institutions and listed businesses to only report suspicious transactions, suspicious activities to the FIU. Clause 12 of the bill seeks to amend Counter-Proliferation Financing Regulations 2025, published as Legal Notice 416 of 2025. Mr. Speaker, the bill before us is important. More than that, it is necessary for us to keep faith with our international obligations and with the mutual evaluation exercise, which, as I said in my opening, is to commence in a fortnight's time. I commend the bill to the House, and I urge all members opposite to support it with one voice. Mr. Speaker, I beg to move.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Treasury Ordinance, Chapter 4 of 1939, the Proceeds of Crime Act, Chapter 1127, the Police Service Act, Chapter 1501, the Registration of Clubs Act, Chapter 2101, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Companies Act, Chapter 8101, the Partnership Act, Chapter 8102, the Registration of Business Names Act, Chapter 8285, the Licensing of Dealers, Precious Metals and Stones Act, Chapter 8406, the Non-Profit Organizations Act, Number 7 of 2019, and the Counter-Proliferation Financing Act, Number 8 of 2025, be now read a second time. Member for Diego Martin Northeast.
Thank you, Mr. Speaker. Perhaps at the outset, before members opposite become too excited, we are going to support this legislation. What I cannot support and what we cannot support is the manner in which the government has dealt with the circulation of this legislation to members. And I distinctly remember on several occasions when the member for Siparia was leader of the opposition, when sometimes we would give up to 1 week's notice on complicated legislation, that the member would complain bitterly that 1 week was not enough to deal with complex legislation, and that the opposition did not have the resources that ministers have in terms of research capability. I distinctly remember that. Yet, Mr. Speaker, this bill, which is 49 pages long, was circulated to us, and only those of us who, for some reason, might be looking at our email would know was circulated to us at 7:45 p.m. on Tuesday night. This is absolutely ridiculous. And Mr. Speaker, I'm asking you if something can be done about this. Because we recognized when the former leader of the opposition complained about getting late notice for complex legislation, that it was necessary to give suitable advance notice. And quite often, before a bill was even laid in the Parliament, a letter would be sent a week, 2 weeks in advance with the bill, indicating to members that this is going to be brought to the Parliament in due course. What this has also caused, Mr. Speaker, today I asked the Parliament where was the bill essentials. And this is a feature of the Parliament introduced some years ago. To assist members, the Parliament will produce a bill essentials which gives a narrative, an explanation, analysis, and assistance to members, in the opposition in particular, to understand the legislation before us. This bill essentials I have in my hand, which is not very long, only a couple pages, was given to me after the session began today, Mr. Speaker, after the session began. That is clearly because of the pressure that was put on the legal department of the Parliament, because they too only received this bill on Tuesday. So I hope in future we will not have a recurrence of this. Going now to the bill itself, when I look at the bill essentials, which a bit, trying to find a proper word, or a bit threadbare, because they are simply a repetition of the preamble, the explanatory note. More or less, that's what it is. That was all that the legal department was, I assume, was able to do with the short notice. Because what is also missing is the effect of these provisions on all of the acts that are being amended today. It has been a practice of this Parliament in the past. Your predecessors, Mr. Speaker, would ask the Attorney General or whoever it is was piloting complex financial legislation in particular to produce a document so that members will understand the effect of each amendment. All we have before us is this, the bill, and this, which is really a really good regurgitation, as I told you, of the explanatory note. The only way we will know how this affects all of the various pieces of legislation being amended is we will have to go to those pieces of legislation. And the Ministry of Legal Affairs has been very tardy in updating the laws of Trinidad and Tobago, notwithstanding whatever boasts that relevant minister may have made. If you go onto the website of the Ministry of Legal Affairs, you are not going to see the most up-to-date version of many of our laws. So what an opposition member has to do is to go through the Parliament website, find every single amendment bill to all of these bills, and then take those amendments, put them into context, and understand what is going on here. So I'm just asking you, Mr. Speaker, perhaps you could correct that in the future. What, as I said to members of it before they get too excited, we are supporting the legislation, but we are not supporting the manner in which the government is treating this Parliament as a rubber stamp. We are not. And what I was particularly disappointed in the introduction by the Attorney General is that he simply gave a sort of a literal explanation of what we are amending this clause and we are amending that clause, but he did not explain the framework, the contextual framework. So I will explain it. I have in my possession, you're getting excited. I have in my possession, I told you we're supporting the bill, so calm down. I have in my possession, Mr. Speaker, a circular letter And we're not asking for any amendments either, because we understand the monkey pants that the government has found itself in terms of its delay, in terms of its tardiness in dealing with this matter. So, Mr. Speaker, I have in my possession a circular letter from the Central Bank dated February 12, 2026, which is not too long ago, 2 weeks ago. And this letter is to all institutions. And the institutions that it has been sent to are financial institutions licensed under the Financial Institutions Act, financial holding companies, insurers, payment service providers, e-money issuers, and bureau de change operators. And it speaks to the FATF compliance and various miscellaneous provisions FATF compliance acts. And it says as follows: the Central Bank advises that the following miscellaneous provisions FATF compliance acts were fully proclaimed and are in effect. Miscellaneous provisions FATF 2020, 2024, 2025. It goes on to explain the purpose of the acts. It then says that the Central Bank held several sessions with regulated sectors between December 2025 and January 2026. You see the tight time frame they find themselves in, to discuss the material amendments. And notwithstanding, it is telling financial institutions now that they should conduct a thorough review of these acts and, where necessary, ensure that all new or amended regulatory requirements are embedded in the institution's AML, CFT, CPF compliance program. And it goes on to speak about a gap analysis. And it says that financial institutions are required to undertake a gap analysis against the acts and develop remedial actions by June the 30th, 2026. The Attorney General said that the on-site evaluation by CFATF will take place in March, next 2 weeks. And what is also important is not just that there's an on-site evaluation. Financial institutions have to look at the legislation, including the one we are debating today, and make sure that they are in sync and compliant with all of this legislation by June the 30th, 2026. And the corporate secretary of these financial institutions must submit to the Central Bank a signed certification confirming that they have done so. You see the tight time frame we're in, Mr. Speaker. We are debating this in the House today. I assume it will go to the Senate Tuesday. And we will advise our other members there to support it. They must support it. And therefore, by the end of February, we will have a new piece of legislation, a Miscellaneous Provisions FATF Compliance Act of 2026. And that gives people March, April, May, June, 4 months for financial institutions. I've read out all of them: banks, holding companies, insurance companies, payment service providers, etc. Just 4 months to look at the legislation, including this 49-page bill, which has now come from the sky upon us, and see whether they are compliant with what is in this 49-page bill. And you know why, Mr. Speaker? It is because of the monumental incompetence of this UNC government. And you know what has caused this incompetence? The UNC government has adopted a scorched earth policy. Anybody who look like a PNM, sound like a PNM, they have just got rid of them. So what they have done, all of the institutional memory, all of the institutional capacity, all of the expertise that had been developed over years, they've just got rid of it. Scorched earth policy, right through the sector. But it is most important, or most negative, that they have done so in the Attorney General's office. Now, in the past, I and other members of the government, the PNM government, had cause to quarrel with one of our former attorneys general, because he kept on all of the persons that the UNC had employed in the office of the Attorney General. When we came in 2015, the person who was made Attorney General, he didn't go through there and just fire everybody willy-nilly. He understood that institutional memory is important, Mr. Speaker. And in fact, we used to buff him and say, why are you keeping these people there? These people are clearly UNC operatives. But he said no. She said no. I need to have them there to maintain continuity and to make sure the knowledge is not lost. Not them, Mr. Speaker. They fire everybody, get rid of everybody, clean house, throw away everybody. Tote bag. And this is why we find ourselves in this situation. In September, Mr. Speaker, would you ask the Minister of Finance to stop muttering across the floor?
Well, I ordinarily would have acceded to that request, but you see, when you engage in it earlier and you invite that, but I will ask all members to please behave. But you engage in it. It's really rich for you to complain about it. But come on, let's proceed.
Speaker,
this is a sterile bill.
You are the presiding officer.
Trust me, I'm aware of that. And I observe seated on this perch chair. I observe the exchange. I don't intervene unnecessarily. So you can't participate in it and then complain afterwards when it suits you. So come on, let's just move on.
Mr. Speaker, when the Attorney General spoke, I was quiet as a mouse. I did not disturb him. I just want to correct that record. I did not say a word when the Attorney General was speaking. And he introduced the bill. And I am asking for your protection. I am responding. I would ask that members opposite do not disturb me. No, not you.
Proceed. The time is going.
It's all right, Mr. Speaker. We have quite a bit of time. So, Mr. Speaker, when the first miscellaneous provisions bill was brought by the government opposite on September the 12th, introduced on September the 12th, 2025, and debated subsequently and then enacted into law, Miscellaneous Provisions FATF Compliance 2025, we told the government that this was a defective piece of legislation. We told them they hadn't done their homework. We told them because they get rid of everybody in the Attorney General's department who knew about this, that they would have to come back on at the last minute, at the 11th hour, a few weeks before the on-site mutual evaluation. And of course, they say, that ain't true, you're talking nonsense, that kind of thing. But here we are, Mr. Speaker. Here we are, 5 months later. Not 1 month, 2 months, 3 months, 4 months. 5 months later, Mr. Speaker, here we are dealing with a Miscellaneous Provisions FATF Compliance Bill 2026. And what excuse does the government have? I looked at what was in the 2025 September bill, and it dealt with the following bits of legislation. And I'm referring to that because the Attorney General, in his introduction, said that the mutual evaluation commenced in August of 2025. And it appears that we may have some kind of difference of interpretation, because when I read what the FIU is saying, it is saying that the mutual evaluation is beginning next month. But it doesn't really matter. We all know that what is happening next month is the on-site evaluation. So it doesn't matter. We wouldn't quibble about words. But when we look at what happened here in 2025, the following acts were amended: Trustees' Ordinance, Prevention of Corruption, Mutual Assistance in Criminal Matters, Proceeds of Crime, Anti-Terrorism, Police Service, Financial Intelligence Unit Act, Income Tax Act, Companies Act, Partnership Act, Registration of Business Names Act, Securities Act, and Non-Profit Organizations Act. What are we amending today? Trustees' Ordinance, the same thing that was amended in September 2025. Proceeds of Crime Act, the same thing that was amended in September 2025. Police Service Act, the same legislation that was amended in September 2025. Financial Intelligence Unit of Trinidad and Tobago Act, same thing that was amended in September 2025. Companies Act, same legislation that was amended in September 2025. Partnership Act, same legislation that was amended in 2025. Registration of Business Names Act, Again, same thing that was amended in 2025. Non-Profit Organizations Act, same thing. The only new introductions are registration of clubs, licensing of dealers, and Counter-Proliferation Act. And the problem I have, we all know, nobody could pretend that they don't know, that there is sufficient knowledge that in the private members clubs that call themselves casinos, that's a real problem in this country, Mr. Speaker. These casinos masquerading as private members clubs. We all know from all intelligence reports, if one looks at the financial intelligence reports, one looks at other security reports and so on, we all know that there is a belief that many of these casinos are operated by questionable characters and that they are linked to organized crime. And so it is in every country in the world. Trinidad and Tobago is not unique in this respect. All over the world, there is a belief that casinos are linked to organized crime and so on. So why in September of 2025 did the government not bring an amendment for FATF compliance? Because that's obvious. If one goes into the FATF recommendations, which I have the 40 FATF recommendations here. If one goes into that, one will see that casino gambling is one of the main areas of focus of the Financial Action Task Force, and the fact that significant money laundering takes place within casinos or within the casino industry. So how come in September of 2025 the government didn't think it was important to amend the Registration of Clubs Act in the way that they are amending it today? And one of the things that the Attorney General did not do, he did not explain why they're doing what they're doing. He simply gave a sort of a literal explanation of the meaning of the words. But let's look and see what they are trying to do with the registration of clubs. In this legislation, they are expanding the ability of the Registrar General to cancel the registration of a private members club. And they are most importantly dealing with the whole question of criminals associated with private members club. And in particular, if the Registrar General has reasonable cause to believe that any information submitted is misleading, false, or deceptive, then the firm must remedy it, and failing which the partners of the firm will be prevented from exercising their powers, apart from dealing with the whole question of trying to avoid criminals being associated with registration of clubs. That's a primary FATF requirement. How come that was not done in 2025? Secondly, for those who know, and you don't have to pretend that you don't know, people who deal in precious metals and stones, again, that is a way to launder money. Instead of dealing in cash or dealing in wire transfers, you buy precious gems and so on, and you transport it over borders, and you launder money in that way. So why in September 2025, the government did not think it was important to address that matter, but they're addressing it now. And this is why I'm accusing the government of monumental incompetence. And they need to explain to the population what is going on. That's the other thing the government is not doing. They are not educating the public on what is going on. And what is so different about the fifth round mutual evaluation, which is going to take place, the on-site evaluation within the next couple of weeks. Why is it being done? And one would expect that when a minister comes to this house to pilot legislation as important as this, that they will have the courtesy to educate the population and people who go to banks. I mean, you know how difficult it is to open a bank account now, Mr. Speaker? For a little man? For a poor person, Mr. Speaker? You know how hard it is to do that? You would have heard people complain, I'm sure you have, about why it has become progressively more difficult over the years. Progressively more difficult over the years. And this is going to make it even more difficult. And therefore, it is incumbent on the government to educate the population as to what is happening and why they are doing what they are doing. And the difference between the 5th round mutual evaluation and previous rounds of mutual evaluation is that the evaluation now has 2 components. A technical compliance, which just looks at specific requirements, legislation like what we're doing today, and this is why we say we support it, because we know this has to be done. Has to be done. Because if we don't do it, we'll go back on the grey list. And just for the record, I want to repeat, we gave a private members day to do this. Oh, look at that, I didn't even know that. And just to repeat, Mr. Speaker, just to repeat that one of the, well, I didn't know that yourself. Right? So just to repeat, in a previous sitting, the member for Barataria had the audacity to say that we were on the Trinidad and Tobago was on the FATF grey list because of the PNM. Not admitting for 1 minute that we were removed from the FATF grey list in 2020 because of the diligence and the hard work of the former Attorney General at the time, Senator Faris Al-Rawi, who intensely passed legislation, went all over the world, meeting with all the counterparts that are members of FATF and so on, to ensure we got off that grey list. But that's not the point. In this particular case, Mr. Speaker, the 5th round will have 2 components in it. 2 components. And what it will have, as I said, the technical compliance assessment. So, as I said, our laws have to be in sync with the FATF, the 40 recommendations. And they evolve all the time. But what is different with this 5th round evaluation, and which takes place next month, is that for the first time, the evaluation will assess the adequacy of the recommendations and the extent to which a country achieved this defined set of outcomes. And it's all about having a robust anti-money laundering, counter financing of terrorism, and counter-proliferation financing. For the first time, well, I mean, there has been focus on implementation in the past. But now in this 5th round, they are going to make sure that Trinidad and Tobago achieves the desired outcomes. So passing this legislation is just one cog in the wheel, one brick in the wall, Mr. Speaker. The government now has to do its work to make sure that between now and the end of the year, all of the various institutions that are affected by this legislation, such as the ones written to by the central bank, are compliant. It's quite a tall order. And what the central bank told the various financial institutions, that the timeline for reporting of suspicious activities and transactions to the FIU must be implemented with immediate effect, the revised timelines, and all other measures to close identified gaps are to be implemented by December 31st, 2026. So, Mr. Speaker, I hope the government understands how complex all of this is. I hope they understand that Trinidad and Tobago is late. I hope they understand that coming 2 weeks before an on-site evaluation of legislation, which cannot possibly be implemented by the time the team gets here, we are skating on thin ice. And for that reason, I mean, they've done it already, but I mean, what else can they do? For that reason, I would urge the government, be careful when you are just exterminating people in a system because they look like a PNM and they sound like a PNM. You are doing the country a great disservice. This is a very small country. This is a very small country. And speaking for myself, Mr. Speaker, I can give you personal experience of that. I remember back in 2003 when I was appointed the Minister of Tertiary Education, Science, Technology, and Tertiary Education. And I called in all the heads of department. And a particular individual came in, a fellow called Fazal Karim. And the name sounded familiar to me, but I gave the gentleman the opportunity to tell me about his achievements, his strategic plan, Mr. Speaker, come on, Mr. Speaker, look, please. So I gave Mr. Karim the opportunity to tell me what he had done, what he was doing, what he planned to do. And then I said, you know, your name sounds familiar. Are you in any way associated with the UNC? He said, yes, I'm the General Secretary of the UNC. And I kept Mr. Karim in that position as the head of that department in the Ministry of Science until I was, I went on to be appointed, Mr. Speaker, I went on to be appointed Minister of Works in May of 2005, and Mr. Karim worked with me between 2003 and 2005. And I did that because I recognized that he had talent. Similarly, Mr. Speaker, they could say what they want, you know. They are masters of deception. They could say what they want. Similarly, Mr. Speaker, when we were looking for a CEO for the Exim Bank, and Mr. Navin Dukaran was ranked first in interviews, and the chairman came to me and said, look, I just want to let you know that we are considering appointing Mr. Navin Dukaran to be CEO of the Exim Bank. And I said, that name sounds familiar. What is he to Winston Dukaran? They said, that's Winston's son. And I kept Mr. Navin Dukaran as, I did not object to the appointment. I kept him as the CEO of the Exim Bank until I demitted office in 2025, and he performed excellently because he had talent. But they are different. They are different. Anybody that smell like a PNM, look like a PNM, walk like a PNM, sound like a PNM is marked.
Mr. Speaker, 48-1, if you could just bring it back to the bill, please.
Yes, and you know you're being irrelevant. You spent so much time. So let's move on.
That's okay. You could threaten me if you want, Mr. Speaker.
No, I'm not warning you. I'm reminding you of the extent of my discretionary power.
Very much. That's cool. You in charge, Mr. Speaker. It's okay. I recognize your authority. I do. I recognize your authority. If you want to cancel my time, that is your prerogative. So, Mr. Speaker, let me go now to the bill. Mr. Speaker, what is wrong? I told them we supporting the bill and stop getting excited. Just because...
30 seconds again. And after speaking for 30 minutes, then you make the proclamation, let's go to the bill. Come on, continue. I will give you your 15 minutes, you know. I will access... Well, let me remind you, you didn't read any clause. All you read is the preamble to the bill and identify the acts which it purports to amend. But let's get on with it, shall we? I will give you your 15 minutes because the 30 minutes has expired.
Oh, thank you so much, Mr. Speaker. Very kind of you. Mr. Speaker, it's okay. Thank you. So, all right. So I won't read the clauses that are recited in the bill essentials, which is what I've been doing. You don't want me to do that? No problem.
For the correction of the public record, stop trying to create that narrative. All I said is that you spent 30 minutes and then you said, let's get to the clauses of the bill. Well, here we are. Finally, you're beginning to jump the hurdles. So let's go. You have
Mr. Speaker, you know I've been talking about the bill for the last 30 minutes. It's okay. It's not a problem. It's all
You
right.
come on, move on.
It's all right. It's not a problem. So, Mr. Speaker, perhaps the Attorney General could explain why in the 2025 legislation and in this one, they have now limited the whole question of trusts that come under the scrutiny of the supervisory authority to express trusts and not constructive trusts and implied trusts. Perhaps that's something that people need to know because it has been queried as to why we are limiting the scrutiny of the supervisory authority to just express trusts. I think that's important. The other thing, Mr. Speaker, there is a clause in the bill which now changes the word society to credit unions. And the Attorney General referred to that and he explained that, you know, a cooperative society may not necessarily be in the business, I am paraphrasing, of finance. And therefore, since this is a finance-related piece of legislation, it was necessary to limit it or to ring-fence it to be credit unions. But I have a question, because when I look at the definition in the bill, this is in clause 2 of the bill. Clause 2 of the bill is defining credit union as a financial institution. Or clause 2 of the Act will define credit union as a financial institution. When you go into the Financial Institutions Act, however, a financial institution under the Financial Institutions Act means a company which carries on or used to carry on all or any aspects of banking business or business of a financial nature, and that is not necessarily a credit union. So I would like the Attorney General to explain to the House and also to the population at large, because the number of persons who are associated with credit unions in Trinidad and Tobago numbers in the hundreds of thousands. That's my understanding, that there are over 100,000 members of credit unions in Trinidad and Tobago. And many of these people are not learned, they don't have tertiary education, and they may not fully understand exactly what we are doing in this Parliament today. And therefore, the Attorney General should explain to the House and the population at large that for the purpose of anti-money laundering and for counter-terrorist financing and so on, it appears from what I'm seeing here, the FIU will be the supervisory authority. So people need to understand this, because the whole issue with credit unions, because credit unions are essentially viewed and believed to be by members of credit unions to be the small people's sector. That is the small people's bank. You know, so many people of limited income, they depend on loans from credit unions to survive, to buy household effects, to buy motor cars and things, to finance housing accommodation and so on. So many people depend on credit unions to give them a loan, which they cannot easily get from a bank. So you're talking about over 100,000 persons who are going to be affected by this change in the definition to credit unions, to make it crystal clear that we are dealing only with credit unions, and that it appears to me that the supervisory authority for the purpose of anti-money laundering will be the FIU for credit unions. So I would like the Attorney General just to, either you can correct me if I'm wrong, or you can confirm that I am correct, so that people will understand, credit union members will understand that the FIU is in their business at this time because of this. Because there have been many attempts over the years, Mr. Speaker, to create a regulatory authority for credit unions, or to put credit unions under the central bank, for example. I remember many years ago, many years ago, we're talking, if I go back in time, we're talking over 15 years ago, maybe 17 years ago, a former Minister of Finance had indicated that it was going to be the policy of the government, he had made a recommendation that credit unions be supervised by the central bank. And there were protests all over the place and so on. And that former Minister of Finance had to go and apologize to the credit union movement for daring to say that the central bank is going to be the regulatory authority for cooperatives. And the other problem that we're having is that these credit unions, their assets are in the billions. And therefore, the Attorney General, I am asking, please explain to persons who are members of credit unions the effect of this legislation. It is also important for the Attorney General to explain to non-profit organizations, people who are non-profit organizations, how this legislation is going to affect them, how this FATF compliance is going to affect them. Because you see, FATF doesn't really care about local cultural norms or traditions or local practices in any country. All FATF is interested in is anti-money laundering, countering terrorist financing and proliferation financing and so on. So, Mr. Speaker, I realize the members on the government side are upset that I've accused them of incompetence, that they're upset that I've accused them of a scorched earth policy, that they're upset that they have brought us to this place where we have a 49-page bill that we have to deal with 2 weeks before our FATF comes here to evaluate our systems. I realize they're upset. So I repeat at the end of all of this, because we know that the government has messed up where this is concerned in terms of the legislative amendments that should have been done since last year, since September 2025, and it should be in the implementation phase at this point in time. We know they mess up, and therefore that is why we are going to support this legislation, despite one or two flaws in it, Mr. Speaker, and we will not ask for any amendments. I thank you, Mr. Speaker.
Member for Barataria, Samuel.
Thank you very much.
Give them some performance. Give them some performance.
Thank you very much, Mr. Speaker, for recognizing me to join this very important debate in order to bring Trinidad and Tobago up to a particular standard so that we can remedy the wrong of the previous administration and finally, Mr. President, be compliant with our FATF regulations and criteria. Mr. Speaker. Mr. Speaker, this bill is an important bill, and the majority of the clauses of this bill focuses on three aspects of FATF and their recommendations: adequacy, accuracy, and up-to-date information. When I listened to the member for Diego Martin Northeast, he was inadequate,
Oh, yeah.
he was inaccurate, and he was out of date, Mr. Speaker.
Always.
Always.
Always out of date.
He was unprepared, Mr. Speaker,
short
and
of
then
it.
blames
Short
it
of
on the
it.
fact that he didn't get enough notice to study this
short of
particular
it.
piece of legislation.
Short
He
of
was the Minister of Finance for 10 years with the cabinet responsibility with respect to this particular FATF recommendations, Mr. Speaker, and he wants more time to study this. He put us in this mess. We are trying to get out of it. We are trying to get out of it. And what he did, Mr. Speaker, he flee from the chamber because he does not want to hear the truth.
That's right.
He does not want to hear the truth, Mr. Speaker. Then I heard he said he has to congratulate former Attorney General Faris Al-Rawi.
Oh, my goodness.
Now, Mr. Speaker, we're in the holy month of Ramadan, and I know he must speak the truth in this month. But what he must say is that he was the same one that was trying to get rid of Al-Rawi.
Oh, gosh.
Yeah. And now today he comes to beat his chest and say, this is good work, and so on. In a holy period like this, he's speaking on truths, Mr. Speaker. He is speaking on truths. Mr. Speaker, if you look at this bill in terms of preparedness and so on, I remember sitting there on the opposition, and never once they would have circulated consolidated amendments. We used to do it ourselves because we were diligent, Mr. Speaker, and that is why we are on this side of the House today. We did our work. The member behaves as though that he alone sits in the office. You have a parliamentary allocation to hire staff. research officers, you can reach out to the Parliament Library, you can reach out to different sources that you may have, and so on. You have Google, you have a laptop, you have an iPad that is given to you by the Parliament, and he comes here to complain that he did not have enough time to study. Mr. Speaker, this bill, if you look at the bill, there are 9 pages before the bill starts with something called an explanatory note explaining every single clause of the bill. Every single clause. So we reject that argument by the member for Diego Martin Northeast with respect to this. If he decided not to read the bill until this morning, that is his problem, that is not our problem. So he then said that he studied the bill in a short time. It wasn't enough time, but he supports it. Mr. Speaker, it probably is a good thing we didn't give him more time. He may have changed his mind. But Mr. Speaker, this particular piece of bill, he introduced some other matters that I need to address, and I need to place accuracy on the public record. He said that we are firing everybody from the AG's office. He said we are firing people, and his words are that we are firing people who look like a PNM, who song like a PNM, and so on. Mr. Speaker, I can tell you, I don't know what does that mean. The member for the Diego Martin Northeast, he probably could explain. But I can tell you, Mr. Speaker, they're accusing us of firing people from the PNM, and today we have a former PNM Attorney General as a UNC Attorney General. You know, our distinguished Attorney General came from the PNM, and today he sits as the current Attorney General of a Prasad Bisesa-led administration. You see what they're upset about? They're upset about is that we are firing, or we are taking back the briefs that was handpicked to select PNM financiers who were lawyers making $1 million briefs at the Attorney General's office. They're upset because Michael Kwamina have no work again at the Attorney General's office. That is what they're upset about. That is what they are upset about, Mr. Speaker. That is what they're upset. Why didn't the member raise the fact that there's a lady called Rohini Ramkisoon, who as minister, he interviewed to determine whether or not she should be a member of the BIR, made false accusations against the lady. The lady had to go to court, and the court ruled that the minister acted ultra-vires, illegal and irrational. That's the man, you know. That's the man. That's the man. Why didn't he talk about when he fired Jawala Rambaran? When the PNM fired Jawala Rambaran? Talk about that. Talk about that. But they don't want to talk about those things, Mr. Speaker. But those are the facts. Facts are stubborn things. Facts are stubborn things. Facts are stubborn things. And then he said that when he was minister, he was so proud of Mr. Fazal Karim. That Mr. Fazal Karim was a beaming employee, that he was competent, that he did an interview and so on. Mr. Speaker, the public record will show. I have an Express article dated the 9th of October 2018. This is what the article reads, Mr. Speaker, the headline. Karim, I cried like a baby when the PNM fired me. What? I cried like a baby when the PNM fired me. I read, Mr. Speaker, former Tertiary Education Minister Fazal Karim said he cried like a baby years ago after being fired by the People's National Movement government. And he quotes here, Mr. Speaker, you know what pains me? As a former Minister of Tertiary Education and the person who is now the Finance Minister, you know who you're talking about, right? The former Finance Minister. He was my boss. He was the Minister of Science, Technology and Tertiary Education, and the PNM fired me too. Yes, I worked under the PNM and I kept my job until there was an instruction to fire me. I cried like a baby to go home and tell my wife that I can't mind her anymore. And you know what my wife told me? She said, greater things are in store for you. And Mrs. Prasad Bisesa made Fazal Karim the Minister of Science and Tertiary Education. So don't come here and talk any nonsense. Don't talk any nonsense here. Let us put the record on the table, Mr. Speaker. Let us put the record on the table. But I want to spend some time on a particular matter that the member raised, and it had to do with blacklisting of Trinidad and Tobago. Blacklisting of Trinidad and Tobago. We found ourselves on two lists. One, the list by the Global Forum, and two, the list by the FATF. Now, both times we found ourselves on on those lists, the member for Diego Martin Northeast was in fact the Minister of Finance, who through his incompetence and the incompetence of that former cabinet placed Trinidad and Tobago in such an embarrassing position. Embarrassing position. It took a UNC government to get us off the Global Forum blacklist. It happened recently. We had the press release this week, Mr. Speaker. And Mr. Speaker, what I want to say is this. I want to say that the history will show this particular Global Forum blacklist matter. That deals with beneficial ownership, it deals with AML, it deals with CFT, and so on. Mr. Speaker, in 2010, 2011 or so, we signed on to that forum in terms of tax transparency all over the world and so on. And in 2014, then Minister of Finance, Larry Hawaii, would have committed that Trinidad and Tobago will become compliant by the year 2017 in terms of sharing tax information with other jurisdictions and so on. We are part of a global network, part of the European Union. There are obligations to us. If you want to do business, you have to join on to this particular system and so on. Mr. Speaker, we know what happened in 2015. There was a change of administration where the PNM came in power. Would you know, Mr. Speaker, this is the Hansard record dated the 9th of September 2016, where the former Minister of Finance, the member for Diego Martin Northeast, he said this. He said, one of the first things I had to do when I was appointed Minister of Finance, and I took up office around the 12th to 13th of September, was to write a letter to Global Forum seeking a one-year extension to a deadline that had been given to Trinidad and Tobago to become compliant with the Global Forum. I indicated, of course, the government had changed, a new government had come in. We needed time to familiarize ourselves with what was happening, and we received a one-year extension to September 2016. That wasn't so. We committed to 2017. But in any event, he said the first day he came into office, he knew about this matter. The first day he knew about this matter. Mr. Speaker, 2015 passed, 2016 passed, 2017 passed. Not a single piece of legislation was introduced in the Parliament by them to further this matter. Mr. Speaker, on the 23rd of October 2017, a letter came from Brussels. A letter came from Brussels, signed by Fabrizia Lapecorella. My Italian is not so good. And the letter says, letter for the attention of the authorities of the Republic of Trinidad and Tobago. And what they said, Mr. Speaker, is that, I'm quoting the letter, the Code of Conduct Group will not recommend to the Council of the EU to include in the list of non-cooperative jurisdictions for tax purpose any country or jurisdictions which commit to correct the identified deficiencies by 31 December 2018. So, he said 2017 will comply, 27 reach. They give us till 2018 now to fix this thing. The minister responds, and the Global Forum asked him to respond to their letter by the 17th of November 2017. You know, he didn't. He responded on the 21st of November 2017. And he wrote to the chair of the Code of Conduct Group, and he committed that Trinidad and Tobago will address our deficiencies by the 31st of December 2018. And the Minister Imber then, gave a deadline and a timeline for the passage of bills. He said the Income Tax Amendment Bill 2017 will be passed by the 30th of June 2018. He said the Double Taxation Agreements Bill 2017 will be passed on the 30th of June 2018. He said the Companies Amendment Bill 2017 will be passed by the 30th of June 2019. He said the Mutual Administrative Assistance in Tax Matters Bill 2017 will be passed on the 30th of November 2018. The BEPS framework will be passed June 30th, 2019. Do you know BEPS was passed in 2024? 2024. Mr. Speaker, do you know the income tax bill? That one, and I'll give the history of that also because that is important. The BEPS was passed in 2024. The Mutual Assistance in Tax Matters Bill was passed in 2024 when he told him he was doing it in when? 2018. The Companies Amendment Bill 2017 was passed in 2019 when he told him he was doing it when? 2017. Mr. Speaker, so you understand why we have found ourselves in this position. We must understand the history. But what they did, Mr. Speaker, in 2017 is they placed 3 particular pieces of legislation in a joint select committee. I was on that joint select committee together with Mr. Karim and Mr. Charles. The 3 pieces of legislation was the Income Tax Amendment Bill 2018, the Mutual Administrative Assistance in Tax Matters 2018, and the Tax Information Exchange Agreements Bill 2018. Mr. Speaker, we had 3 meetings of the JSC. The first meeting on the 6th of June 2018 lasted 17 minutes. The second meeting of the 21st of August 2018 lasted 57 minutes. The third meeting on the 20th of August 2018 lasted 1 hour and 11 minutes. And if you add all of those bills together, you will probably find about 200 pages of legislation. So in all, the JSC met for about 2 hours and 25 minutes, Mr. Speaker, and you know what they did? They took out one of the bills from the JSC, the Income Tax Amendment Bill. They said we have to pass this one only. We said no. We are willing to deal with all 3 bills together. They said no. They pull out one bill, Mr. Speaker, trying to mama guide the EU people in terms of the Global Forum requirements to show that they're doing something, Mr. Speaker. And you know what happened to us? We found ourselves on the blacklist. We found ourselves on the blacklist. So don't let them come to this house and say, Mr. Speaker, that they are the savior of this country. They are not. They are not. They have placed us on this embarrassing list, Mr. Speaker. What they have done, that is what they have done. It took us, Mr. Speaker, a UNC government to have finalized this particular matter. We had to finalize it. And then they like to tell us that we don't support legislation, and they issued a press release outlining 10 pieces of legislation. I pull the record, Mr. Speaker. I had to pull the record. They like to say we don't support the Tax Information Exchange Agreement Bill 2020, supported by the UNC. The FATCA Bill, Mr. Speaker, supported by the UNC, Mr. Speaker. The Mutual Administrative Assistance in Tax Matters Bill, supported by the UNC, Mr. Speaker. The Special Economic Zone Bill, supported by the UNC, Mr. Speaker. The BEPS Framework, Mr. Speaker, supported by the UNC. The Miscellaneous Provisions 2023 Bill, Mr. Speaker, supported by the UNC. The Miscellaneous Provisions Bill 2023, supported by the UNC. And there's another miscellaneous bill that came in 2024 that was also supported by us, Mr. Speaker. So our track record is clear on this matter, Mr. Speaker. It is clear. But why we found difficulty with the Income Tax Amendment Bill at that time, Mr. Speaker, it is because they were trying to insert the Minister of Finance and giving him powers to look into taxpayers' information without proper judicial oversight. That is the effect of that bill. That was the effect of that bill.
Make him designated.
They pull out that one bill from the JSC, Mr. Speaker, to do that.
Sorry, 48-6, Mr. Speaker. Let me remind the Speaker that it is this government that placed 2 of its own members on the board of the BR, and not the former Minister of Finance.
That's irrelevant, overruled. That's a fair and proportionate response.
Much, Mr. Speaker. You see, Mr. Speaker, the truth hurts. You see, my friend from San Fernando East was a minister in the Ministry of Finance, but he never went to work. So he don't know what was happening inside there.
Step in the boundaries there. Come on.
He does not know what's happening in there. So I will ask and I will encourage my friend to speak on matters that he's familiar with. That is all I will tell him.
That is not the one. That is not the one.
And not basketball, as my friend from Morupuch East is reminding me. Mr. Speaker, I want to get... Mr. Speaker, there are other matters where I have to respond to the member for Diego Martin Ortiz. He said this, Mr. Speaker, with respect to the members' club and the casinos and so on. And I have the words here. He said, the whole question of criminals associated with private members' club, and in particular the Registrar General, if she has reasonable cause to believe that any information submitted is misleading, false, deceptive, the firm must remedy it, and failing which the partners of the firm will be prevented from exercising their powers, apart from dealing with the whole question of trying to avoid criminals being associated with the registration of clubs, which is a primary FATF requirement. Mr. Speaker, you know the bill doesn't say that? You know the bill doesn't say that, Mr. Speaker? The bill makes no amendment like that with respect to the registration, the private members club. It does not say that. My friend read the wrong section and applied it to the private members club. He read the section that dealt with the amendments to the Partnership Act, Mr. Speaker, and applies it to the registration of members of clubs act, Mr. Speaker. He was totally inaccurate. He's inaccurate. This is simple reading, Mr. Speaker. If you look at the bill is very clear. And he found that, Mr. Speaker, that particular clause, and I'll find the clause here, at clause 5 of the bill, which is found at page 11, and then what he does is that he mixes it up with the amendment from the Partnerships Act, Mr. Speaker. So we cannot accept any arguments from my friends opposite because they speak confidently, but they are confidently wrong, Mr. Speaker. They're confidently wrong. So there's nothing with respect to that particular matter, Mr. Speaker. Mr. Speaker, there's another thing where he said it's so difficult to open a bank account in this country. Who made it so? Who made it like that? The member for Diego Martin Northeast was the Minister of Finance who made it so difficult for people to open a single bank account in this country. He did it, Mr. Speaker. And you know what would have caused that, Mr. Speaker? Because when you place yourself on these blacklists and these grey lists, you are under enhanced supervision. So therefore, those were the factors that would have led to the ease of doing business being more difficult and more difficult to open a bank account. So the blame lies squarely at the feet of the member for Diego Martin Northeast. Personally, what we are doing right now, Mr. Speaker, as I said, is cleaning up the mess of the PNM. Cleaning up the mess. We are 9 months in government, and the majority of the time that we take is cleaning up the mess that they left us in. That is what they left us in, Mr. Speaker. Mr. Speaker, I want to get to the various clauses of the bill, and I'll pay particular attention, or I will deal with only a few of the clauses. The clauses that deal with the Trustees' Ordinance, because they fall within the Ministry of Land and Legal Affairs, the Companies Act, the Partnerships Act, the Registration of Business Names Act, the Non-Profit and the Non-Profit Organizations Act. Those are the particular clauses that touch and concern directly the Ministry of Land and Legal Affairs. Mr. Speaker, sorry. Mr. Speaker, when you look at a clause-by-clause analysis, at clause 2A of the bill, 2A and 2B, what we're dealing with is with respect to correcting a reference error with respect to trust, now making it express trust, and the member made an issue with respect to why are we including these trusts and so on. FATF says that all express trusts must fall within the regulated framework of the jurisdiction. And what they have recommended, we are in fact doing here, Mr. Speaker. It applies to express trust. That is what it applies to. Then we go on, Mr. Speaker, to clause 2, subsection D. And this really, again, as I started the debate, it's also to ensure that we have accurate, we have adequate, and we have up-to-date information. And that is what the clause says. In addition to the information contained in the register, the trustee of an express trust or administrator shall hold basic information on other regulated agents or service providers and so on. Because what they have identified, Mr. Speaker, is the trusts can be used as vehicles or as guides or so on for monies to move in a particular direction. What they're suggesting is that these trusts now must keep a register of all of their service providers and other agents and so on that do business for the trust. And the information is very basic, but it must be up to date. It deals with the identity of the owners or directors of the service providers, nationality, address, and relationship to the trust, and any form of legal arrangement. The information must be accurate. If it's changed, it must be updated within 5 days, and you must have a 6-year retention of the records. That is standard, Mr. Speaker, that you have a 6-year period in which you keep records. And if the FIU requires any information, they will do it within or upon a written request. So that is where you have a level of diligence and due diligence that they can't just come in. They must have a written request. Also, the register that I just spoke of must be kept in a particular place in Trinidad and Tobago, not out of the jurisdiction, and competent authorities and so on can also make requests for information that is contained in those registers that the trust has in fact maintained. Mr. Speaker, the other substantive clause would have dealt with clause 2, subsection 2D, subsection 4, Roman 4, which deals with the suspension and so on. And this is very important because where the trust or person of, or of an express trust fails without a reasonable cause to send any report, return, notice, document, or prescribed fee to the Registrar General, or the Registrar General has cause to believe that any information is misleading, false, deceptive, in a material particular contained in the report, the return notice or document that is required under the ordinance or the regulations to be sent to the Registrar General. The Registrar General may send by post or deliver in electronic form to the trustee of an express trust or administrator or any other legal form or published by means of the approved by the Registrar General a notice outlining the defects, and they give them, Mr. Speaker, on the following day, after 30 days after the notice, the default, if it's not remedied, what they can do, the powers of the trustee may not be exercised, so you suspend the powers of the trustee. And in respect of an express trust, after the 30 days, after the remedy period, unless the default is remedied, the registration of trust will be cancelled. So the two remedies, Mr. Speaker, in a nutshell is this. What happens? The Registrar General believes the information is false, deceptive, or they did not provide a particular report or document asked, a notice or return. You have 30 days to rectify. If you don't rectify within 30 days, the powers of the trustees are in fact suspended. Following 30 days after that, so now you have 60 days. If after 60 days you still have not rectified the information, what happens is that the registration of that trust shall be cancelled, and within the law, no express trust can function unless it's registered. What's so difficult about that, Mr. Speaker? If you read the bill very clearly, this bill could be read within a few hours, Mr. Speaker. The member for Diego Martin Northeast would have understood what the bill was doing. It's not difficult. It's really not difficult. And you will see a similar clause being replicated throughout the bill, because what we're doing is we're applying it to partnerships, we're applying it to companies, and we're applying it also to business names, Mr. Speaker. No difficult thing, no rocket science. So I don't understand why the member for Diego Martin Northeast was complaining so bitterly about the notice period. And in fact, the notice period that we gave was prescribed within the standing orders in this House. Mr. Speaker, I move on, Mr. Speaker, to the issues with respect to the other clauses of the bill that deals with the company's registry. Mr. Speaker, the company's registry amendments deal with amending Section 9 of the Companies Act, and Section 9 deals with the incorporation of a company. And the incorporation of a company, what we're doing is that we're asking that the words that we include, that sometimes the Registrar General may ask for any other supporting documentation. What in fact that means, when I had a briefing session with the Office of the RGD, was that you normally ask the persons who are incorporating, the directors at the time and so on, to provide identification documents. So that is what this simply means, that they can provide any supporting documentation. And again, this will touch and concern FATF methodology criteria 24.6A and 24.8 to ensure, again, Mr. Speaker, information is adequate, accurate, up-to-date, and also the beneficial ownership information is in fact up-to-date. When we look again, Mr. Speaker, what we're doing is that we are amending Section 33 of the Companies Act, and this deals with the transferring or issuance of shares. What happens, Mr. Speaker, is that within 30 days from the date of the share, the information must in fact be transferred to or notify the Registrar General, and there are the particular forms, the statutory forms, in which that must be done, Mr. Speaker. Mr. Speaker, when you look at the amendment, it replaces the subsections that clearly set out the both that share forms and the beneficial ownership forms must be filed within the 30 days of any change. And now what happens, Mr. Speaker, is that you have a particular period of time. You had a particular period of time, which is the 30 days, and that is no longer there because, again, FATF requires you to have up-to-date information. So therefore, that form, that 30 days is no longer part of the Act, Mr. Speaker. Mr. Speaker, when we go on again to the other clauses of the bill, it deals with the company to ensure that the information on record at the Office of the Registrar General is current, and a company that fails to ensure that the information is current and correct, they will commit a criminal offense, and that offense is $10,000 or imprisonment for 3 years, and for every day in which the offense occurs, a further fine of $100. Mr. Speaker, that also is with respect to the FATF criteria, simply to show that we must have fines and penalties that are dissuasive for persons to ensure that they provide correct and accurate information that will be held within the registry. Mr. Speaker, the other one is where the Registrar General believes that a company is not carrying on business or in operation. He may send to that company by post or email a letter inquiring whether the company is carrying on business, and if they are not carrying on business, stating that if any answer is not received within that 3 months after sending the letter, a notice will be provided in the Gazette. So we're giving them a second bite of the cherry, Mr. Speaker, in that regard. And what the Registrar General can do, if the answer that is received indicates that the business is not carrying on business or does not receive a response within the 3 months, in fact, what the Registrar can do is the ultimate sanction of striking that company out of the register, and the legislation will deem that the company shall in fact be dissolved. So what we had done, Mr. Speaker, there was a particular striking out activity that was done. We introduced the amnesty. When I became the Minister of Legal Affairs, we had an amnesty. We had several companies that were in, with respect to being struck out or had late filing of documents, benefited from that amnesty. So therefore, we know exactly now who are really the companies that are operating, because you had several companies on the register that were really not working or not functional. Now we have a good indication of who are the functional companies, and we realize again on the second round that there are still companies that are failing to provide or file the necessary documentation, and those companies will in fact be liable to be struck out.
15 seconds, unless you wish your 15 minutes.
I will avail myself, Mr. Speaker. Thank you very much. So, Mr. Speaker, what we have in fact been doing at the Ministry of Land and Legal Affairs is that while we have the legislation in place, we are in fact, Mr. Speaker, what we are being tested on is effectiveness, and what we are doing is through the operations of the Registrar General's office is showing that the legislation is now being put in operation, and it is in fact effective, Mr. Speaker. And of course, we, while going through the operations, may realize that there are legislative amendments to be made. Those legislative amendments are brought to the Parliament, and that is why we are here, Mr. Speaker, to fix some of the issues that we may have encountered, and that is why we are doing this, because we want to put Trinidad and Tobago on the best foot forward when we are going to be assessed by our international colleagues. That is what we have been doing, Mr. Speaker. Mr. Speaker, the other clause deals with at page 17, and this is subsection K, which now introduces the prosecution of offences and so on, where the Registrar General can in fact give notices, and in lieu of a criminal fine or a criminal sanction, if a person pays the administrative fine, they can in fact be the administrative fine can rescue them from criminal liability, Mr. Speaker. And Mr. Speaker, this is not a new invention. It is in fact found in the Securities Act, so that is something that we have looked at also. With respect to the Partnership Act, Mr. Speaker, and not the Registration of Clubs Act, I think my friend from Diego Martin Northeast had issues determining which clause applied to which act. The Partnerships Act says, Mr. Speaker, that if a firm within the 30 days of receipt of a statement to verify the identity of a beneficial owner, update the register of beneficial owners, and so on, and other supporting documents. And if the firm knowingly or recklessly makes or provides a return that is required under the Act, and it contains statements that is false or misleading, and omits to state material facts, Mr. Speaker, it commits a criminal offense. And what it goes on further to say, Mr. Speaker, is that if the Registrar General, it appears to the Registrar General that the information is inconsistent with other information in previous records, because the Registrar General is the ultimate record keeper, the Registrar General may give notice stating that the information appears to be inconsistent and requires the firm to amend and also to give further information. What the Registrar General can do now, Mr. Speaker, is that you can remove the inaccurate record that was filed and registered, and the correct information according to the now subsection 6. The Registrar General will be able to replace it with the accurate information. So that is what this particular clause would have done, Mr. Speaker. The Registration of Business Names Act. Again, this deals with if you provide false or misleading information, you can suspend the powers of the partners, and then afterwards you can cancel the registration. Mr. Speaker, then the last material parts of this bill that deals with the Ministry of Land and Legal Affairs has to do with the amendments to the Non-Profit Organizations Act. Mr. Speaker, we understand, and I want to say this to the listening public and the general public, that I have been encountered by several complaints with respect to the Non-Profit Organizations Act and registration of same, that it may be a very cumbersome process. I can give you the assurance that we are looking at it to rectify it, Mr. Speaker. Some of my colleagues have raised issues with me having sports clubs and village clubs and so on, having some difficulty in the registration and even to file subsequent documents to be in compliance with the law. I can give the undertaking, Mr. Speaker, that we are looking at it, and I give the undertaking to our international partners that it will all be in compliance with our international regulations. So while we balance our domestic complaints and needs, we also have to ensure that we are meeting our international obligations, because I don't want to have a situation where we are not able to comply with our FATF recommendations and so on. And Mr. Speaker, again, this is a replication of the clause with respect to ensuring that the information is accurate and that there are no inconsistencies, and the prosecution of the offenses is the same with respect to the non-profit organizations where there's an administrative fine that can be paid in order to escape from criminal liability, because you give an opportunity by first telling you what the breach is, telling you what the fine is, and if you fail to rectify, then the criminal sanctions are tripped. However, what we have done is place it in a tier procedure that we don't want to have persons face criminal consequences who may have made an honest error or honest mistake or may not know what they have been doing. But what we want to do is ensure that the legislation is robust enough to capture those persons who may be using these NPOs and NGOs as vehicles to drive criminal activity. So it's a very delicate balancing activity that we are doing right now, Mr. Speaker. So without whittling down or watering down our international obligations, at the same time we understand some of the difficulties that the local NGOs and so on are in fact facing. Mr. Speaker, this bill is in fact a very robust piece of legislation brought by the Office of the Attorney General through the Ministry of Finance. It is a bill that we are happy to hear, or I think the opposition is forced to have supported this particular piece of legislation because they have us in this situation, Mr. Speaker. And this piece of legislation, Mr. Speaker, will assist greatly in ensuring that Trinidad and Tobago is placed on a good footing together with our international partners, because, as the Prime Minister said, Trinidad and Tobago is open for business. And in order to be open for business, we must have our house in order. And this UNC government is putting our house in order to ensure that we have a prosperous Trinidad and Tobago going forward. And with these few words, Mr. Speaker, I thank you very much.
As I recognize the member for San Fernando East, I see it's now almost 4:18. The tea break is 4:30. I don't know, and I'm going to throw this out for the member, whether he wishes to start or whether he wishes to take the adjournment now.
Good night.
Very well. So we will come back at 5:15 at the usual time. Thank you. The House is now suspended until 5:15. Thank you. Member for San Fernando East.
Thank you, Mr. Speaker. Mr. Speaker, we're here yet again to discuss yet another slapdash, piecemeal piece of legislation by this government. What this legislation is supposed to do is to modernize the financial system and tax collection system of this country. But that is not what we get from the other side. In their rush to do things and to send this document at last minute again to those on this side, they have again offended many aspects, we believe, of the FATF requirements. In fact, we are scheduled for a FATF evaluation, I believe I heard in the next few weeks. And it is our belief on this side that this country will fail that evaluation, Mr. Speaker. And not by any other reason than by the incompetence of this government and its ability to present legislation that does not make any sense. Mr. Speaker, they want to speak about delays in achieving agreement with many of the international bodies. And there are three particular bodies that Trinidad and Tobago is subject to in terms of its financial regulations. We have the EU, which has been explained ad nauseum, Global Forum, and of course, FATF. Mr. Speaker, the one thing that they did that would have made things a lot smoother would have been to implement the Trinidad and Tobago Revenue Authority, Mr. Speaker, which was meant to modernize the system. It would have expedited many matters and ensured that this country would have been compliant a lot sooner. They want to blame the former government, talk about legislation from 20 whenever. That's what they did. Their first meeting in this House, in this term, would have severely improved and modernized the financial and tax collection system of Trinidad and Tobago. Mr. Speaker, ostensibly, this bill is called Aligning the Trinidad and Tobago's Legal Framework with FATF Standards to Strengthen AML, CFT, CPF Compliance. Mr. Speaker, and there's several groupings within this bill, within its clauses. We have trust and beneficial ownership transparency, corporate and partnership compliance, non-profit organizations oversight, which has its complications, and the member for Barataria Sawa admitted that in his contribution. Precious metals and stones licensing, administrative fines and enforcement mechanisms, Mr. Speaker. It also creates several new innovations that have been explained in the legislation. New powers for the Registrar General, authority to query discrepancies, impose administrative fines, strike off companies, major compliance upgrades, Mr. Speaker. We understand that. It also expands great powers to the FIU of Trinidad and Tobago. What we're asking is how does this legislation offend other pieces of legislation which are in train for Trinidad and Tobago? And one in particular comes to mind. There's an aspect of the bill that deals with the credit unions. Right now before JSC, we have a credit unions 2014 bill drafted by those on the other side, which will eventually come to this House, which is intended to bring credit unions under the management and control of the central bank. That was drafted by those on the other side. Yet here, we have a bill that does the same by putting those credit unions and other bodies under the management of the FIUTT. Our question is, which one is it? Where's the confusion? Why is it that one bill says one thing and it offends another that this government intends to bring to this parliament? We need an explanation. Some of the major innovations of this bill: express trust transparency, clearer obligations for trustees to maintain and disclose beneficial ownership information quickly within 5 days, administrative fines regime, Registrar General's expanded powers, we explained that earlier, the FIUTT oversight expansion, beneficial ownership reporting, cross-sector harmonization. All of this is intended for this bill. But, Mr. Speaker, it is difficult to take any kind of upgrade or modernization of a system intended to combat white-collar crime from a government that we know is not serious about dealing with white-collar crime in this country. And I will go on to explain exactly how that goes. Let's take a look, Mr. Speaker, at the clauses of the bill. Clause 2, the Trustee Ordinance, Cap 4 of 1939. This clause, Mr. Speaker, clarifies that provisions apply to express trusts only. Trustees, administrators must maintain accurate records of beneficial ownership and service providers. Records must be updated within 5 days of changes and retained for 6 years. Registrar General empowered to query discrepancies and impose administrative fines. False or misleading filings, offense with fines up to $10,000, Mr. Speaker. Mr. Speaker, that may be okay for many of the larger businesses in this country, but for many of the smaller SMEs, it will be a major challenge. We've added yet another level of bureaucracy and fines to some of the smaller businesses that are already being challenged by many of the taxes that have been foisted on this country by this Minister of Finance. We have a Minister of Finance who's clearly determined to tax this country into a recession, and that is exactly what is happening out there in our community. We have businesses going out of business at this point in time. Businesses that would have survived recessions, would have survived
Mr. Speaker,
hurricanes.
48-1, this bill is not about that.
Yes, it is.
Move along.
No problem, Mr. Speaker. Thank you. So, Mr. Speaker, you're adding yet another tax and another level of red tape and bureaucracy to businesses that are already being challenged. They, as I said, they survived the recessions, they survived COVID, and many of them couldn't last 9 months under this Minister of Finance. It is very challenging. This is another challenge. Mr. Speaker, limiting scope to express trust may leave loopholes in other trust types, constructive and implied. Now, we heard earlier about express trust, and yes, that is exactly what the international bodies have asked for. But you also have to consider the spirit of the law, not just the letter. We have to close these loopholes to ensure that we can challenge money laundering at any level in Trinidad and Tobago. The 5-day update requirement is overly rigid and burdensome for small or family trusts. It could discourage legitimate trust formation due to compliance costs. Again, red tape and cost are a major challenge for many businesses in Trinidad and Tobago. For Clause 3, the Proceeds of Crime Act, Chapter 1127, expands definitions to include credit unions and entities under the Financial Institutions Act, Mr. Speaker. Broaden supervisory authority coverage to virtual asset providers, insurance and securities. Updates financial obligations, regulations to exclude utility bill payment services from money transfer businesses. Mr. Speaker, expanding definitions to include credit unions and virtual asset providers imposes disproportionate compliance costs on small community-based institutions. Yet again, it's more red tape, it's more bureaucracy, more challenges, more costs, more fines. What is this government doing to promote small businesses in Trinidad and Tobago? When the previous government was in office, the non-energy sector at one point had outgrown the energy sector of Trinidad and Tobago. And that was not by accident. It is because we had placed several incentives to grow and develop businesses in this country so that they could employ people and really boost the economy of Trinidad and Tobago. Many of those incentives have been washed away by burdensome taxes. It is unnecessary. This closes the casket on many small businesses in this country because they're not going to have the means, whether they be involved in sport, whether they be involved in the arts, to maintain this and also aspects of the procurement legislation. It is just too much for many. Mr. Speaker, Clause 4. The Clause 4, the Police Service Act, it corrects a cross-reference error, Section 49B. Mr. Speaker, correcting cross-reference errors is minor, but you can argue that legislative energy is better spent on technicalities rather than substantive reforms. And we would have mentioned that earlier in the proceedings. Clause 5, Registration of Clubs Act, defines FIU-TT and AML CFT CPF terms. Licensing committee may refuse registration if applicants have convictions of fraud, dishonesty, or financial crimes. Well, Mr. Speaker, that would certainly rule out several members of the current government if you consider what is going on. It is true.
That's just outrageous. Come on, you know the rules. You're the first to complain about breach of that rules from the other side. Withdraw it and move on.
Mr. Speaker, does the rule exclude me from telling the truth?
Withdraw it and move on.
Mr. Speaker, I withdraw.
Move on.
Mr. Speaker, Clause 5 says the licensing committee may refuse registration if applicants have convictions of fraud, dishonesty, or financial crimes. FIU-TT, designated as supervisory authority for clubs. Mr. Speaker, is that true or not true? It's true. It's a fact. There are several members of the government who would not qualify to apply under this piece of legislation.
Can I just now ask you, which member of the government there has a conviction?
So they know themselves. They know themselves.
Conviction.
Mr. Speaker, there are several members of the government who are currently out on bail. That is not my fault. That is a fact.
Well, plainly, you do not know the difference between an allegation and a conviction. You have a duty as an elected member speaking in a debate to represent the facts and the law correctly. You know very well that there's a vast and fundamental difference between an allegation and a conviction. You've persisted in saying the most outrageous things. And I asked you to withdraw it and move on. You cheekily said you would withdraw it, disingenuously at that. Then you come back with it. There's a vast difference. Perhaps you're not aware that the presumption of innocence applies to whoever is on bail. There is, point to one of them who has a conviction. A conviction. Why would you say something so outrageous, knowing fully well it's not true? Move on, and I'm putting you on notice. One more instance of this, and I'm going to invoke the rule under 55.
Thank you, Mr. Speaker. Greatly appreciate your guidance. Clause 6, FIU Act, Chapter 7201, defines non-profit organizations, Mr. Speaker, extends FIU-TT's powers to monitor non-profit organizations, request documents, and issue directives, requires FIU-TT to cooperate with domestic and international regulators. Mr. Speaker, issues that we have extending FIU powers to NPOs and listed businesses may stretch resources too thin. Does the FIU have the prerequisite ability to manage all of these new responsibilities? And that's exactly what the former Minister of Finance had said earlier. We have an evaluation in just a few weeks. We bring this legislation today. How soon can it be enacted? It will not be enacted. And that is why we believe that we are going to fail the next evaluation in the next few weeks. And the government will look for all kinds of people to blame, everyone else but themselves. We are saying it is them. Moving on, Mr. Speaker. Clause 7, Companies Act, Chapter 8101. Companies must notify registrar of share transfers, redemptions, and beneficial ownership changes within 30 days. Registrar empowered to strike off companies for false or misleading filings. Administrative fines introduced for offences. Registrar may inquire into inactive companies and strike them off after notice periods. That gives vast powers to the registrar of this country, Mr. Speaker. We are saying that 30-day reporting requirements for beneficial ownership changes may be impractical for complex transactions. So yes, again, Mr. Speaker, we see the theme. We believe that many of these requirements are going to add a layer of complexity and bureaucracy and red tape to many businesses in this country that will just be too much for them. It will put them out of business, as this Minister of Finance has already put many businesses in this economy out of business. The last thing we need at this point in time is additional red tape and bureaucracy. Could create duplication of oversight with other regulators. As I said earlier again, there's a piece of legislation making its way to this House that is intended to bring bodies under the control of the central bank. How does that interfere with what is being done here today? I hope the Attorney General can answer that question when he winds up. Smaller MPOs may lack capacity to comply, leading to unintended closures, as we said. The Partnership Act, Clause 8, defines authorized corporate service providers, requires partnerships to verify beneficial owners and file certified returns. Registrar empowered to query discrepancies and impose administrative fines. False or misleading filings offense with fines up to $10,000. Well, nothing excites the Minister of Finance more than new fines. That we understand. Mandating certified filings by partners or corporate service providers increases costs for small partnerships. Administrative fines may incentivize or pay to comply behavior rather than genuine adherence. Could discourage informal partnerships from formal registration, Mr. Speaker. Again, more red tape. Clause 9, Registration of Business Names Act. Registrar may issue notices if filings are misleading, false, or deceptive. Registrar's power to act on reasonable grounds may be too broad, risking arbitrary enforcement. Does the Registrar General have the resources and the ability to enforce many of these new powers? We are saying that we do not believe that is the case. So we have a piece of legislation that says one thing, but the reality is something different. And the people involved in the FATF evaluation will not be fooled. Clause 10, Licensing of Dealers, Precious Metals and Stones, Act Chapter 8406, bars licensing of applicants with convictions for fraud, dishonesty, or financial crimes. FIU-TT, designated as supervisory authority for dealers. Court may cancel licenses upon conviction. Clause 10. Blanket bans on licensing individuals with prior convictions may be overly punitive, ignoring rehabilitation. Could conflict with reintegration policies and limit economic opportunities. Judicial discretion may be undermined by automatic license cancellation. We are saying that there is not enough here being left to discretion of those involved. It is extremely punitive and draconian. Clause 11, Non-Profit Organizations Act number 7 of 2019 clarifies definitions to apply to express trusts. Registrar empowered to query discrepancies in NPO filings. Administrative fines introduced for offences. FIUTT oversight extended to NPOs. Extending FIUTT oversight risks overburdening charities and community groups. It's a common theme, Mr. Speaker. Compliance costs may discourage civic engagement. Proportional oversight, focusing on high-risk NPOs, would be a more balanced intervention. And that is maybe an amendment that we can consider. Instead of all NPOs, we should be aware that there are certain types of NPOs that are far more likely to be involved in wrongdoing than others. So instead of casting a broad net, let's focus on the ones that are more likely to be up to wrongdoing. Mr. Speaker, Clause 10, Licensing of Dealers, Precious Metals and Stones Act, Chapter 8406, bars licensing of applicants with convictions for fraud, dishonesty of financial claims. FIUTT designated as supervisory authority for dealers. Court may cancel licenses upon conviction. Mr. Speaker, it's something that we should also be very careful about, because a lot of older people in this country save their money by purchasing precious metals. Many may not still trust banks. As we know, with our grandparents, many of them, instead of keeping dollars in a hidden place, they prefer to buy jewelry, because it's a lot more hardy, wouldn't be eaten by rodents, it will survive a flood, survive fire. Those persons who may want to sell their jewelry and so on at different points for cash may feel that they may have to register to do that, and they may have difficulty. We have to also consider the culture of Trinidad and Tobago when implementing some of these rules. Clause 11, Non-Profit Organizations Act number 7 of 2019 clarifies definitions to apply to express trusts. Registrar empowered to query discrepancies in NPO filings. Administrative fines introduced for offences. FIUTT oversight extended to NPOs, Mr. Speaker. So, Mr. Speaker, fines may be perceived as revenue raising rather than deterrence. I'm sure the Minister of Finance has heard that many times. Risk of uneven enforcement or bureaucratic overreach. Uniform rules across sectors ignore sector-specific realities, creating disproportionate burdens. Mr. Speaker, going to the clauses of this bill, it is clear to us that it was not completely thought through, and that this bill in no way maintains the spirit of what is being offered to us in terms of modernizing our financial system. It is just not being done. We are going to have an evaluation next few weeks. We are not going to pass this evaluation because this bill in no way assists us in achieving the goals meted out to us by these international agencies. So we're asking those on the other side, please, let's have something that makes sense. We're also insinuating, as I will explain, how the non-cancellation of the TTRA would have allowed us to comply with the mandates of this FATF bill much sooner, much faster, in a much more meaningful way. Mr. Speaker, let me remind this House and the people of Trinidad and Tobago that the Revenue Authority, what was its main purpose? To combine the tax functions, income tax, VAT, customs, excise, under one unified body, instead of separate agencies. That's exactly what it is the modernization of our financial system is about. Collection and enforcement, responsible for assessing taxes, collecting payments, auditing taxpayers, and enforcing compliance. Information sharing, coordinate with financial intelligence units like the FIUTT and other regulators to detect tax evasion, money laundering, and illicit flows. Risk-based oversight, use data analytics to identify high-risk taxpayers or sectors for targeted audits rather than blanket enforcement. That is what the TTRA was meant to do. That is exactly what the EU, Global Forum, and FATF have been asking this country to do. And what those on the other side decided to do, their first day in office and in this parliament, was to cancel this venerable body. Other modernization strategies, digital transformation, online filing and payment systems reduce manual paperwork. All of that is for modernization. Data analytics and AI, integrated registries, Mr. Speaker, customer service, orientation, international standards and alignment. That would have been the impact of the Revenue Authority. Greater efficiency, credibility, fairness, investment climate. That is what we're looking for. And how this links to the FATF compliance, Mr. Speaker. FATF requires countries to demonstrate effective monitoring of financial transactions to prevent money laundering, terrorist financing, and tax evasion. The TTRA would have played a critical role collecting and analyzing tax data that can reveal suspicious activity. And that was the main purpose of the TTRA, Mr. Speaker. The TTRA would have democratized tax collection in this country. And by doing that, it would mean by compiling all of the different agencies, no one would have been able to slip through that net. It would become a lot more difficult. It was intended to close a $10 billion annual tax gap in this country. If this government was serious about white-collar crime, they would not have cancelled the TTRA. Again, the TTRA, cooperating with the FIUTT, or Financial Intelligence Unit of Trinidad and Tobago, to share information on potential AML-CFT risks, ensuring beneficial ownership transparency through company and trust filings linked to tax records. The creation of the TTRA was part of a broader package of reforms aimed at satisfying FATF recommendations and addressing EU concerns about tax governance. That is what the TTRA was about. So when members come to this House and say that the PNM this and the PNM that, and the PNM was delaying this bill and we were supported and so on, that is just not the case. The facts don't bear that out. We were doing everything required to ensure that we were in compliance with these international agencies. Those on the other side came in and they tore it all down. And now they are rushing to try to meet compliance with a slapdash piecemeal piece of legislation that we know will have absolutely no effect in reality. None. And that is exactly why we will not pass muster in the next evaluation, Mr. Speaker. So, Mr. Speaker, it's a simple, straightforward bill, Mr. Speaker. And as dealing with the EU, dealing with FATF, dealing with the Global Forum, we knew that we were well on our way to meeting with the compliance, and really working with these various agencies so that Trinidad and Tobago could modernize our system. And in modernizing the system, we mean that we would be dealing with white-collar crime in Trinidad and Tobago. Mr. Speaker, we maintain that those on the other side are not serious about dealing with white-collar crime. Mr. Speaker, I thank you.
What is being noted. San Fernando East, I'm going to put it on record that I think what you did there, you were being deliberately offensive. You knew very well what you were doing. You withdrew it, you came back. I'm not inviting a discussion.
Mr. Speaker, then I too would like to put on record that I believe that you...
Have a seat. Have a seat. Have a seat. Have a seat. I'm going to require you to apologize to the members and the House for making what you knew to be a deliberately false, misleading, offensive, and insulting remark.
Mr. Speaker, I did not, and I already withdrew the statements.
I'm going to require you to apologize.
I withdrew the statement as you requested initially. I withdrew it.
I'm going to require you to apologize. And if you do not apologize, I, pursuant to 55(1), I'm issuing you a formal warning.
Mr. Speaker, I withdraw and I apologize.
Thank you very much. Order Spain not.
Thank you very much, Mr. Speaker. Mr. Speaker, the piece of legislation before us today is a continuum. And I think it's important to start by putting this into some context, especially for those whom we represent, who may not be fully aware and cognizant of how this may affect them and their daily lives. And I'll start, Mr. Speaker, by just talking or putting on record the body called FATF, that we use the acronym, because we've been using it now for well over a decade. And FATF stands for Financial Action Task Force, an international body that was formed really, Mr. Speaker, to combat and to tackle the issues of money laundering, terrorist financing, and financing of proliferation. And how this affects small island states such as ours is that we are required to be part of the international financing community and to participate globally in banking arrangements via things like correspondent banking. And this body has the responsibility to try and regulate global financing, and in particular to deal with those areas I've just identified. And very often, because of how small we are in the scheme of things, they make requirements of us that are, one, very difficult for us to fulfill, two, affect us in ways that we really have no control over, because our loss of correspondent banking would be disastrous to us all, and in particular to the constituents and the citizens that we represent. For example, they will no longer be able to send or receive money abroad and to receive money from persons abroad, no longer be able to easily conduct financial business transactions, paying for goods, ordering goods, and these types of things. And one of the disadvantages that we frequently found ourselves at in Trinidad and Tobago and many, many other CARICOM islands and nations is requirements are put on us without an appreciation of how we effectively really live life and do business, for example, in Trinidad and Tobago. Within the past decade, we have had at CARICOM level to rush off, for example, to the US Capitol and to ask for meetings with congressional hearings before, for example, Representative Maxine Waters from California, who at the time was in charge of the financial congressional body, to alert them to some of the difficulties that we were being put in. So, for example, very often Trinidad and Tobago, not only with FATF, but with the Global Forum, we are somehow labeled as some sort of tax forum, which we all know we are not. We have no IBCs, we have no protection from tax in Trinidad and Tobago, but they put these responsibilities on us. And today, this bill has to plug some of those gaps that once again, when we are looking at it, we are concerned and it's our duty just to register. And this puts no blame on the government because we have been there. We have been there, and I recall back in 2016 when it was all falling down because we came in 2015 and met that we were already on the grey list, about to go onto the blacklist. And we were required to pass legislation that required special majority. And unfortunately, at that time, our friends on the other side who were in opposition made it quite clear that they were not going to provide their support. And it led to a crisis because we were just a few days before becoming blacklisted loss of correspondent banking, and we came to Parliament and they said they would not support the legislation. We on this side have taken a decision that for the sake of Trinidad and Tobago and to ensure that our citizens continue to be protected, we will support the legislation. But we are very cautious, and it is our duty to record some of the concerns that we have. So to go back to that 2016 incident, I remember the time it was member for Trin City Maloney, Senator Al-Rawi and myself, who were appointed by the government to meet with the opposition, to sit down with the legislation, to try and get their support, because we were about to lose the correspondent banking. And if it was not for the citizens of Trinidad and Tobago being alert to what was going to happen to them, that they could no longer send or receive money from their children, send money to their children or receive from their children, conduct their business, it would not have happened. And the responsible opposition that you're seeing here today is not going to put Trinidad and Tobago into that trauma again. But what we must do is point out, one, that they continue to impose on us requirements that, quite frankly, are unnecessary in our environment. And I'll get to it. For example, when you look at the whole trustee provision, this came out of an attempt to combat corruption globally over the past decade, where they started going after trusts. But Trinidad and Tobago is not known for a second as a province, as a country, as a sovereign nation that offers some sort of trust legislation that protects people who are trying to money launder or to hide funds. And one of our concerns is we sit here and we pass legislation. And I remember many times over the past 10 years, we had to come here as a PNM government and ask those on the other side for their support. And hear all sorts of things about good legislation they will support, and this is bad legislation, and why they wouldn't support and put the country through trauma. And say, but you all coming to amend again, and you amended 2 years ago and to make a whole tralala of that. The truth is, it is because bodies such as FATF continue to move the goalposts, and that is why we're here today, about to face another scrutiny from persons of outside of Trinidad and Tobago, that if we don't pass this today, we will fail. But the reality is, even if we pass this today, we are still at risk, because it is not only about the passage of this legislation, but more importantly, it is about the enforcement. And one of our serious concerns, because we're seeing it, is have other pieces of legislation that have similar provisions that are supposed to help us to get over these hurdles. Have they been assented to? Have they been proclaimed? There is nowhere that we can go to easily to see and to match. And I'll ask on our behalf that the next time, because there is going to be a next time, and it may be only a matter of months or weeks from now, we will be back with another similar miscellaneous bill. I'm going to ask that the government on the next occasion provides the opposition with the sort of consolidated amendments, because it is a number of pieces of legislation. And if we're to assist in doing our jobs properly and to contribute, the least that could be done is, when you're sending these bills, send us the same thing that you have that is prepared by the public servants, to see, okay, well, these are the amendments to the trustee ordinance, which, as Mr. Speaker would be well aware, is a law from 1939. That in itself shows that Trinidad and Tobago is not a jurisdiction that provides specific trusts that people are hiding behind. But we are faced with being a small fish in the global scheme of things and this international reality. It is not proportionate, Mr. Speaker, for countries as small as us who are placed with these burdens and these obligations. The next point that is of concern to us is very often, because it took us years to get Trinidad and Tobago off of that grey list, and the then Attorney General having to make numerous trips to Paris and to here and there and everywhere all over the world to meet with people, to convince them, to put us on the radar, to let them know what we're doing, the difficulties we're having with the passage of legislation to fulfill their obligations that really mean the world to us because it's turning us upside down, but nothing to them. We are not a tax haven. There's no beneficial trust in Trinidad hiding the millions and billions of dollars. The truth is those places are in Miami, they're in London, as we know. The majority of real estate in London is owned by sanctioned people. But the focus is put on us and the pressure is put on us, and that is why we're here today. And the failure, if we as a country are to not comply with these requirements, would be disastrous for us. So again, I ask in the future, because we will be back here, the goalpost constantly moves, and not for a nefarious reason, because the truth is when you're combating criminality, especially white-collar crime, these are people who are very creative. So as you plug one loophole, within a matter of days, they will find another loophole. And then FATF would put more requirements and say, you need to do this, you need to do that. And I share the concerns of the previous speakers on this side, including the member for San Fernando East. Because what we are told and what our understanding is, having managed the process for the last 10 years, is if we don't implement, so not just pass the legislation, but properly implement what will come to in the bill, we are going to fail. And having worked our way over the last 10 years off of the grey list, it would be a disaster for Trinidad and Tobago. So on occasions like this, with these pieces of legislation, Mr. Speaker, through you, we ask the government, provide us with the information in advance and as much as in advance so that we can look at it and we can work with you on it and we can do the responsible thing, unlike what they did for 10 years. Mr. Speaker, this piece of legislation starts with amendments to the Trustee Ordinance, Chapter 4 of 1939, to plug a new loophole that has arisen, I assume pointed out by FATF or CFATF, to say cover express trust. So not only constructive trusts or other types of trusts, but now express trust. And again, when you know a little bit about trust law, express trusts are the ones you should be least worried about. Because, of course, as its name suggests, you are listing who the beneficiaries are, you're listing what the properties are, etc. But it is a requirement, so we must get it done. And when we turn to the provisions dealing with the express trust, it is a requirement at Clause 2, making the amendments to the Trustee Ordinance, to add the word express trust instead of where the word trust exists. And really what it is doing, Mr. Speaker, is quite sensibly asking for information to be provided on a register, and specific information. And then whenever there's a change within 5 days, you have to update it. So I asked the Attorney General, are we in a state of preparedness, as we know how difficult it is? For example, well, the member for Barataria Sawa isn't here. And I just remembered, I think that the Registrar General falls under him now, that department. I stand to be corrected. So many changes. But are they in a position to get this done when we pass this law? We know that we had to continue providing amnesty after amnesty. I heard the member for Barataria Sawa say with much aplomb, as though he was the one that achieved something by an amnesty for registration of companies. The truth is that was absolutely necessary because the systems could not catch up. The systems were not in place. The implementation couldn't be done for well over a year. And now, I ask the Attorney General, we are saying, is this a FATF requirement to go as short as every 5 days? Because we know it trusts. So, for example, there are companies, professional companies that provide trusts and trust services. And very often, they are the executors of the trust. They are the trustees. And they work on instructions. So suppose now there's a change by the person who has set up the trust, or the beneficiaries become aware, and that doesn't happen within 5 days. The consequences of not having it accurate and up to date and updated within at least 5 days of being there change. The reality is, in our daily life in Trinidad, that is almost impossible to achieve. Is this something that we can look at? Is this something that the Attorney General can say, listen, 5 days is not plausible in Trinidad and Tobago? Because as it is right now, you have to set up appointments to get via online systems, to get an appointment at the Registrar General's Department. Can you do this online? But what if you are a company providing these services professionally and the information doesn't come to you within that 5-day period? Look at it, the failure to provide the information. You go on at new clause 3D, 9. Because of the amount of amendments, it's a little bit difficult to follow. But the clause that talks about the failure to provide information, where a trustee of an express trust or administrator of any form of legal arrangement fails without reasonable cause to send any report, return, notice, document, or the prescribed fee to the Registrar General, or the Registrar General has reasonable cause to believe that any information is misleading, false, or deceptive in a material particular contained in a report, return, notice, or other document that is required by this ordinance or the regulations, blah, blah, blah. And it then goes on to set out what the consequences of it are. That it can actually be, the trust can be cancelled. It can be cancelled. Is this now going to be the nail in the coffin that drives these companies that provide professional trust services out of business? Because the banks used to do it. There used to be a company set up by Royal Bank Trust. They're no longer in existence because the burdens just became too difficult for them to carry, the administrative responsibilities. But it affects the everyday person. It affects a parent who wants to set up a trust for their children or their grandchildren, and they want to go to a professional company. So is this something that can be looked at? Is this something that the Attorney General has some leeway with in speaking to FATF? To say, listen, we need some more time administratively. This is not possible. The next one, Mr. Speaker, is, and you see here, the prosecution for offences. Again, a sensible provision is being put in place that gives the Registrar General some leeway to issue a notice before you're sent for criminal prosecution. So a notice, correct this, fix this, or payments by administrative fines. Sounds good. Seems to be a good policy. But when one looks now at the administrative fines, they are actually very, very expensive. We are not setting up legislation for the ultra-rich. We're not setting up legislation for companies that form trusts for other companies and this type of thing. So when you look at it, so Schedule 2, what the new proposed Schedule 2 on page 7 of the bill. Schedule 3, so inserting after Schedule 2 the following schedule, Schedule 3. Offences in respect of which criminal liability may be discharged by payment of an administrative fine. Sounds like a good policy. But should we not look at these administrative fines? So look at the first one. 2A12, failure by a trustee or administrator to register an express trust or other form of legal arrangement. The criminal penalty is $10,000. The administrative fine that the Registrar General can issue for less than 6 months is $10,000. More than is 15. That one seems reasonable, except that you're putting this burden now on the trustee or the administrator. A trustee or an administrator works on the basis of instructions. Suppose now the instructions are not clear enough, or the instructions can't be carried out. What does it now mean for these fines? The second one is of concern to us, at 10C, subsection 3, failure of a beneficial owner without reasonable cause to submit a statement into the trustee or administrator. The offense is an offense of the criminal penalty on conviction is $10,000 and imprisonment for 3 years and $300 every day. The administrative fine is double that, $20,000. Are these the administrative fines that are being put on us put on us, Trinidad and Tobago, by FATF, without any ability on our part to say, no, we want our fines to be lower? Because if they can be lower, maybe we should have a tiered system that if the trust is over X amount of dollars, then it's a higher fine. Because it is not proportional if it is a small trust, as we have, especially in some of our close-by jurisdictions. Not that that would affect Trinidad, but you know that especially the older folk, that is what they used to do. These are some of our concerns. Clause 3 is now dealing with trying to capture credit unions under the Proceeds of Crime Act and making a specific amendment that deletes the word and the use of the word society and substitutes it with the word credit union. Again, on the face of it, very understandable, because on the face of it, we know that the credit unions can be a place, can be, I'm not saying that they are or that there's a proliferation of it, but they can be a place that is used for money laundering because, of course, they have less regulations, they have less strictures, they may have less know your customer, less anti-money laundering provisions in place. So it makes sense to try and regulate them. Again, something that we were looking at over the last 10 years, something I'm sure the government will be coming to Parliament with in the not too distant future, if they get the mandate to try, for example, to put credit unions under the central bank as a regulatory body. Because we've seen in this country the disaster the credit union movement, if it is not properly regulated, can be with the Hindu credit union and the massive losses that are caused to tens of thousands of those in our society. But when we look at this, we have concerns on this side because we know the difficulties. Again, the implementation. Are we in a position to implement? FATF is not going to just say, okay, you've passed legislation. They're going to want reports now on the implementation on the administration side. Another thing we were alerted to is that, unfortunately, a lot of the public servants, the technocrats, with the institutional knowledge in this area, have been terminated, they've been let go. At the Office of the Attorney General, at the Ministry of Homeland Security, where NAMNAP used
we
to
have
be.
heard the issue of people being fired before when Diego Martin Northeast spoke.
Yeah, but I don't think the member is spending a lot of time on it, so I think it's some context.
And the point is that not only institutional knowledge is lost, but as I said at the outset, to get past with these bodies like FATF and Global Forum, it is relationships. Because to them, Trinidad is not even a speck on a map. But when they know the name, they know the face, there's somebody they deal with that they've built up credibility and a reputation that they say, okay, the government is doing all that it can and is taking the legislation to Parliament, give them a little bit more time. That is what counts in reality. So the terminating of people has far-reaching consequences, and that is a concern. We then go, Mr. Speaker, to Clause 5, which deals with the registration of clubs. Now, registration of clubs and the clubs that they're supposed to license with the licensing committee, we all know, because it's a global problem, is an area that very often attracts serious money laundering and also very often terrorist financing. Because, of course, huge amounts of cash are passing in these institutions. So again, because one of the first things you do as a young practitioner, well, back in the day anyway, is you may appear before the licensing committee. But times have changed. And now to see the licensing committee being given this new mandate and an expansion and broadening of its power, again, on the face of it, it appears to be a good policy. It appears to be a move in the right direction. So the licensing committee to which an application is made may, in its discretion, refuse to order the secretary to enter any club in a register if, in its opinion, the return furnished under Section 5 is incomplete. 2, the evidence as to the objects of the club or the system of management or as to the character of the club premises is unsatisfactory. Persons knew when you were appearing before those licensing committee that they would say, yes, there's a book, a membership book at the entrance that everybody has to sign, and everybody in town knew that nobody was signing the book. Well, it's become even worse now from the point of view of lack of accountability. So this is a good power to give to the licensing committee, but then on paper, but then when you get to the reality now of implementation, we all who practice know the difficulties with licensing committees. And do they have the administrative capability? Do they have the infrastructure to support them? The records to support them, to provide the type of information that this legislation envisages to stop the ills that it is trying to stop? And then they talk about the applicant as owners, directors, beneficial owners, or senior employees where applicable has been convicted of an offense involving fraud, dishonesty, deception, a financial crime, etc., etc. And Mr. Speaker, on that point, allow me to just digress a little bit as it dawned on me listening to a previous conversation. Whilst there's some of us here who practice law and some, like Mr. Speaker, who have a lot of experience, not everybody knows the difference between being charged and a conviction. But this, to be useful, this to be enforced, we are asking the government, make sure that the licensing committee now has the access to records. They're not going to be now subject to appeals. They're not going to be subject to challenge. Who is going to provide this information with respect to convictions? Where is that information going to come from? Is it going to come from the police who are supposed to be assisting the licensing committee? These are the things that need to be put in place for this to make sense, and it is not just a facade. You then go on to Clause 6, Mr. Speaker, the Financial Intelligence Unit of Trinidad and Tobago Act. And this now is dealing with predominantly non-profit organizations and NPOs. Again, we recently, within the last 5 years, passed legislation, amendments, again, due to these obligations, to now capture NGOs and to put strict requirements on these NGOs and to ensure that they have audited accounts and to open up a special section at the registry, the company's registry or the Registrar General's department for the registration of these NGOs. And now is giving the FIU a power, notwithstanding any other remedy available to it, if in the opinion of the FIUTT, an NPO for which it is the oversight authority has violated or is about to violate a guideline issued by the FIUTT, the FIUTT may issue a directive to such NPO to take action. So rather than rushing straight to prosecution, you're giving them some ability to try and enforce the law. But the concern with this one for me, and for us on this side, Mr. Speaker, is when you look at Clause 6B, Clause 6C, and in particular C2, by inserting after subsection 3 the following subsection, and it's a new subsection 4. And this is of serious concern. The FIUTT, in performing its functions under this section, may A, cooperate with, B, provide information to, and C, receive information from. And look at how bland it is, how vague it is, how wide it is. Licensing, regulatory, supervisory, and other authorities in Trinidad and Tobago or elsewhere as may be agreed between the FIUTT and those authorities. So presumably via MOU or MOA, a Memorandum of Agreement, we are now giving the FIU this power to provide information to anybody that is a regulatory body or supervisory body, an authority, the broadest one, or other authorities in Trinidad and Tobago. What is the definition of an authority? But we're giving them the power now to dispense with persons' information under this, with respect to NGOs or whatever else it may cover. That is a red flag. Why are we doing that? You then go to the Companies Act. And this again is dealing with the issuing, transferring shares, membership interests.
Unless you want your 15 minutes.
Not the full 15, Mr. Speaker, but thank you. You now look at under the Companies Act. A company when issuing or transferring shares, again, on the face of it, could be a good provision. And I can see the logic behind it. But the question to the government is, will this be done? How is it going to be enforced? Where is the administrative backbone? Where is the administrative support to implement this? Because that is always the issue. How are you going to make sure that with these private companies, when there's a transfer of shares, that it really happens, that when they come to say, look, I've transferred the shares and I want to insert it at the registry, that is there? Because right now the infrastructure doesn't exist. You flip the page, and you see that a company that fails to ensure the information of the Office of the Registrar General is current and correct, commits an offense and is liable on summary conviction to a fine of $10,000. This, to me, Mr. Speaker, is the biggest red flag of this bill that I ask the government to consider. Because this is, when you apply this to small contractors, you apply this to small entrepreneurs who are now using a company that they've set up. So, for example, before with CPEP contractors, to get a CPEP contractor contract, you had to have a limited liability company. Very often, these persons were now starting companies or are small contractors. If they slip here, it's now a $10,000 fine. Many of them are struggling to get business, struggling to survive out there. So we're going to strike their companies off. Why are we taking these fines? It's just like all of the legislation within recent times. Is this increase, this massive increase of fines? Again, consider a tiered system. If you're a larger company with revenue and revenues of millions of dollars, that's fine. That's nothing for them. But this will literally shut down many of the small entrepreneurial companies in our constituencies. I can tell you in East Port of Spain and in Belmont, when they miss those deadlines and they then come and say, MP, I went down and I'm trying to get my BIR, and they say, well, the company, I forgot to file my document. They don't even know what the documents to be filed are. And now they're going to be burdened with a $10,000 fine. Why is the government putting the nails in the coffin of these small people? Reconsider this one, please. And then the striking off the companies as well. Not those who are trying to make an honest living. Again, you have the administrative fines. When one looks at the administrative fines, Mr. Speaker, it's our position on this side that the fines have now shot up. And when you start to accumulate them, they will again cripple and shut down businesses. You do the same, the Partnership Act, similar provisions, the changes are similar, and really it is partnerships that are dealing with beneficial owners and trusts and companies that are set up like that. You have the Licensing of Dealers, Precious Metals and Stones Act. Anyone who's serious about fighting corruption will know that is another area that money laundering takes place very frequently, because it's easy to move precious minerals like gold and other things anywhere in the world. Mr. Speaker, we are going to be back here several times over the next year with similar type of legislation. Our requests remain. We on this side will support the legislation. We have raised sensibly concerns that we have, and in particular some of the concerns that we believe that should be looked at and carefully amended. Ask FATF, look, we want to apply these things to our own personal jurisdiction without burdening and collapsing an economy that is already under stress and struggling, especially the smaller businesses. We've gone through this before, and unlike those on the other side when they were in opposition, that on every single occasion did not want to support the government and took the country to the brink of losing correspondent banking, this opposition will once again, being a responsible opposition, having given it thought and consideration, do what we consider is right for Trinidad and Tobago, and we will support it subject to the concerns we've raised, hopeful that they will be taken on board. With those words, Mr. Speaker, I thank you.
Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I struggle to follow the three speakers opposite who spoke. Diego Martin Northwest started off by saying, I apologize sincerely and on bended knees. Diego Martin Northeast began by saying that he supported the legislation. San Fernando, thank you. San Fernando East raised a number of issues, and I was, at the end of it, I was left, well, I didn't know whether he was supporting or not supporting the legislation. Port of Spain North, St. Anne's West said that he was supporting the legislation subject to. So that is, I think, on any assessment of things, three separate views from one, I presume, united opposition. More than that, I think I could distill the complaints against the legislation that is before us into three broad categories. One I would describe to be hurry. And by hurry, I mean, well, all of the synonyms. Haste, we were rushed, they were prejudiced, they had 49 pages to read in 2 days. I might be wrong, it may be 3, it may be 1, but let's say 2 days. Now, that is not true. And I say that because there's a context to this entire thing. As one of the three of them said, this is not new. It began in 17th, this fifth round exercise began on the 17th of August, 2022. Let me just be abundantly clear about that. 17th of August 2022, when CFATF, the Caribbean Financial Action Task Force, writes a letter to the Honorable Attorney General and Minister of Legal Affairs. The letter is dated the 17th of August 2022. And the material part of the letter says this: while the FATF has not yet finalized their own plans for the fifth round, we want to give Trinidad and Tobago a very, no, the opposite of hurry is early, a very early indication so that preparatory efforts will commence. In the paragraph after that, this is what they see in the penultimate line. In an effort to meet the deadline for presenting CFATIV's first fifth round MER, the on-site will have to occur within the first quarter of 2026. Now, I think a year has 12 months. A quarter of that is 3 months, January, February, March. So since August of 2022, they were told, August of 2022, they were told that there would be an MER, the first MER, fifth round MER, in the first quarter of 2026. That's March. Okay? And they go on. That's not the end of it. They say, which will mean that official engagement with the mission team could begin from as early as July of 2025, I must say in brackets, or soon thereafter. So when my colleague from, when the member for Diego Martin North East says that he don't know what took place in August. Well, what took place in August was exactly what they said would take place in August in 2022. 4 years almost to the day. They began the fifth round evaluation. And that's all that I will say about this red herring, because that is what I heard here this evening. A number of red herrings about dates. August as opposed to this, as opposed. So let's just put that to one side. What was their response to that letter of the 17th of August 2022? Now, I want to repeat that, 17th of August 2022, colleagues. Well, in September the 18th, not of 2022, 2023. This is a year, I was never good at maths. I know my limitations, but I believe that September of 2023 is a year and a month after August of 2022. They write. And what do they do in this letter of September the 18th, 2023? 2 words. They grovel. And by that I want to, if you don't believe me, I'll use the last two, the penultimate paragraph. Now, the letter is written by a colleague of mine, colleague of Mr. Maraja's, but I have to tell the truth. It's a letter. It says, in light of the above, he says a number of things. He says, listen, they have THA elections. Don't ask me what THA elections has to do with this. He didn't talk about Carnival. He said THA elections. He said they have general elections. And then in the last 2 lines, he said, in light of the above-mentioned circumstances, I write, not to request, I write to formally request that Trinidad and Tobago's MER be deferred till later in the fifth round MER process. What does that mean? He gave up. He didn't say, put it back to 2026, 2027. Put it back to sometime in 2026. Put it back to 2029. Put it back to 2050. He said, defer it till later in the fifth round process. Well, you know what happened? Nothing. They ignored that, as they should. So that's why we are here this evening. It's not haste on our part, it is sloth and laziness and incompetence on theirs. So, Mr. Speaker, Trinidad and Tobago will be the first country to be evaluated. This process did start in August of 2025. We are some fortnight away, 2 weeks away from the on-site visit. We have done everything that is necessary up to this point, and including what we are about this afternoon to make us ready. Now, I pause there for a second. And I heard this from both Port of Spain, North St. Anne's, West, and Diego Martin, North, East, that a number of firings took place in the AG's office. True. Say again? True. True. Now, what we did not hear was this. You see, you don't just walk in and say to someone, well, I don't like how you look, leave. Or, I don't like how you look, you're a member of the X party or Y party, leave. But when you occupy a position as important as some of these individuals did, if you happen to live in Scotland, if you happen to live in Scotland or spend most of your time in Scotland, and you work in the Attorney General's office on a part-time basis, well, full-time but part-time,
Full-time salary.
you draw a salary which is equivalent to or more than that of any of us on this side, ministers, and the Attorney General, who gets a few cents more than most, and the Minister of Finance, who does as well, with the possible exception of the Prime Minister. And you, yes, you have a relationship with persons in the field. You're not on my staff. You are not employed with me. And I make no excuses. I make no excuses for asking those persons to find employment elsewhere. And you know what? You know what? The proof is in the pudding. The fact of the matter is that notwithstanding all of that, all of the cleaning house, we are here this evening on a about to be evaluated with that team in place leading the charge, a team of dedicated public servants leading the charge, all of whom I might add are resident in Trinidad and Tobago and doing an 8-hour job in the Republic. Now, Mr. Speaker, I'd like to digress for a second because there was one substantive point that was made by two speakers, and I'm leaving San Fernando East completely out of this.
He out of it,
okay?
He's completely out of everything.
I'm leaving I don't touch San Fernando East, you know. I don't touch, never touch San Fernando East. So, Mr. Speaker, with your leave, so about 25 years ago in the United States, you had a couple of psychologists who came up with something called the Dunning-Kruger theory. Now, that was, I hear some of my colleagues giggling. Now, they observed that people with limited knowledge on a particular discipline. Now, that don't mean to say that they don't know anything about it, but they have limited knowledge of a particular discipline. That they often overstated their own competence and knowledge of a few things within that discipline. Now, they even went as far as to say, well, these are the symptoms of persons who fall prey, victim to this. And they said that they are overconfident, they appear to be overconfident, and they tend to shout. Now, I don't know which one of us, I didn't hear that, but I don't know which one of us in here this afternoon, this evening, might have been shouting a bit. But let's, with that, I want you to bear that in mind because, you see, if you have a limited knowledge of something, and then you come to say, well, okay, as the member for Dugo-Martin Northeast did, he said, the express trust, he said, I don't know what it means, why not the constructive trust or the implied trust? Now, I want to say two things, maybe three. First of all, because we are speaking to Trinidad and Tobago, and not all of us are lawyers, a trust is an old concept in law. All of my colleagues on this side who have knowledge of the law would know that. And it's a device where the true owner of an asset passes it to someone else to hold for him. Now, usually, the purpose is avoidance, some sort of tax benefit or other benefit. But he wants to shield his legal ownership by passing the title to someone else. Now, the legislation before us this evening speaks of express trust. Something is express if it is written down, if it is known. a constructive trust is not written down. How can you legislate for a constructive trust, or worse yet, an implied trust, something that comes after the fact? The law could only bite on express trust. So that is the technical answer to the questions, because there were two. One from one person and another from another individual. But there is an answer why the FATF has targeted express trust. Express trust are those which are written down. And yes, Trinidad and Tobago might not be a huge jurisdiction in terms of an offshore center, but there are many individuals in this country who have millions of dollars. And I dare say, I have found out several, I see Mr. Mirage looking at me because, and I see the Minister of Finance looking at me, because we now know certain things. These are not people who hold millions of dollars and millions of dollars. These are people who hold in the very, 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 very high millions of dollars. They don't hold them often in their hands. They're held in trust for them. And those are precisely the individuals that the anti-money laundering experts on the outside want to get under the gun. And you know who is not standing in front of them to pretend that I am blocking for them? Me. And you know who is not standing in front of them to pretend that she is blocking for them? The Honorable Prime Minister. So, Mr. Speaker, I ended my contribution by asking all members to support the legislation. I was heartened when Diego Martin Norty said that we are going to support the legislation. My heart flickered a bit when I heard the contributions of some of the others. But you know what? We welcome their support. We want their support. We encourage their support. But at the end of the day, we are here to serve the people of Trinidad and Tobago, and come what may, this legislation will pass this afternoon, with or without your support. Because it is in the interest of the people of Trinidad and Tobago. Mr. Speaker, I beg to.